of the Veterinary Medical Board. I warned everybody I'm coughing today, so I'm going to keep that under control.
And that's why I'll be leaning this way.
Yes. And Anne Marie will call roll.
Dr. Waterhouse.
Present.
Dr. Sullivan.
Here.
Dr. Nunez.
Here.
Dr. Nolan.
Here.
Jennifer Laredo.
Here.
Lee Heller.
Here.
Judy Mancuso.
Yes, ma'am.
We have a
And
quorum.
what about me?
Oh, Kathy Bowler.
I'm here too.
I'm sorry, Kathy.
That's okay, I'm quiet over here.
Yeah.
Okay, we have a quorum. Introductions by the public is voluntary, but if you'd like to introduce yourselves, that would be welcome.
Elisa Dowd, veterinary from Danville.
Stephen Satal, National Association of Veterinary Technicians of America.
Kristen Hagler, President of the Academy of Physical Rehabilitation Veterinary Technicians. Cynthia Wallace, California Consumer and Veterinary.
Gilpa Consumer Vet.
William Cho, I'm the assistant professor at UC Davis. I teach small animal case.
Karen Troy, I'm a small animal veterinary practitioner here in Columbus.
Susie Abel, I'm a firefighter, paramedic in Oakland, and a pet owner.
Elizabeth Fine from veterinary medical board.
John Pasco, UC Davis.
Candace Rainey, veterinary medical board.
Sorry?
It's you. I'm Jay Kerr. I'm general practitioner from San Ramon.
Josh Kelsey, physical therapist, San Diego.
Danielle Robbins, physical therapist, San Diego.
Janet Van Dyke, veterinarian, American College of Veterinary Sports Medicine and Rehabilitation.
Amy Kramer, physical therapist, Florence, California. Karen Atlas, president of the California Association of Animal Physical Therapists. Shalon Forrest, small animal massage practitioner and canine fitness trainer.
Scott Conrad, consumer, Los Angeles.
Dr. James Sims, assistant professor at Loma University and the past president of the California Physical Therapy Association.
Grant Miller, regulatory director, CDMA.
Marshall Scott, veterinarian, CDMA.
Valerie Fenster, executive director, CDMA.
Ken Pulaski, president, CDMA.
Bill Grant, NBC.
Leah Schifelt, CDMA, RBT committee.
John Kling, board chair, MDC.
Cindy Savory, RBT, Sacramento Valley Veterinary Technician Association, along with CDMA.
California RBT Association.
Berlin, California RBT Association.
Thank you. We will on to agenda item number 3. We will look at the minutes from our January meeting. Any members have any corrections?
There's an extra "was" on page 9, third paragraph. We need to delete the second one, perhaps.
Yes,
Thank you.
got it.
There is a little typo on page 7, proposed amendments instead of proposed, under the Judy Mancuso, Kathy Bowler motion.
And where's that?
It's the first bullet on page
Right here.
7.
Yes.
To adopt proposed amendments.
Thank you.
Anything else? Yes.
Good morning, Ellen Moon, California RVT Association. I recall from the last MDC meeting, Dr. Klingborg did instruct the task force, hopefully I'm using the correct wording, to include CARPTA in the discussion for shelter medicine along with SHAC. That's since not happened. And so I'd like to get that included into the minutes if that's possible. Would be on page 7, paragraph 4 from the bottom.
So that should be the shack in addition to carved to. Is that?
Sorry, what were you-
So just a bit, just a bit of confusion on my end. So that was said, but not reflected in the minutes, correct? Is that, okay,
We can check the webcast.
okay.
Okay.
So we will check the webcast, and we'll sort of do a pending motion. If that's correct, then we'll add this in, okay? I'm not disputing the veracity, I'm just want to make sure we're there.
So is there a motion?
I'll motion to
Second.
adopt
The minutes.
As
As
amended.
amended.
as amended.
Second.
Okay.
Okay.
Anne Marie will call for the vote.
And let's go
Any
for
discussion?
public- any
Yeah.
public
Oh,
other-
any more public comments?
Okay. Dr. Waterhouse?
Yes.
Dr. Sullivan?
Yes.
Dr. Nunez?
Yes.
Dr. Noland?
Yes.
Jennifer Laredo?
Yes.
Kathy Bowler?
Yes.
Lee Heller?
Abstain.
Judy Mancuso?
Aye.
Okay, on to agenda item number 4, discussion and possible board action on reappointing members to the MDC. And Dr. Pollard's not here, is he? Okay, so Anne Marie is going to handle this one.
So Dr. Pollard obviously is a current member of the Multidisciplinary Advisory Committee, and he is up for reappointment. So we would entertain a motion to reappoint Dr. Pollard.
I have a question.
Sure.
So we have to share this? Oh, God. Really? They have to. Was there any other candidates?
No.
So no candidates, just Dr. Pollard up for reelection? All right, I'll motion to elect Dr. Pollard for reappoint, yes.
Okay.
Thank you.
I'll second.
Thank you. Any other comments?
Any comments from the public? I can tell you that Dr. Pollard has been a very valuable member of the MDC, and he's, from his letter, you can see he's quite self-effacing and modest, but
Yeah.
he's very valuable.
Okay, and then go ahead and call for the vote. Dr. Waterhouse?
Yes.
Dr. Sullivan?
Yes.
Dr. Nunez?
Yes.
Dr. Noland?
Yes.
Jennifer Laredo?
Yes.
Kathy Bowler?
Yes.
Lee Heller?
Yes.
Judy Mancuso?
Yes.
Thank you.
And perhaps Dr. Pollard will graduate from medical school.
Yes.
From middle school. His letter says he feels now he's in middle school, and perhaps he'll graduate.
He has quite a sense of humor, too, yes. Okay, on to agenda item number 5, discussion and possible board action on reappointing a member to the Diversion Evaluation Committee. And as I understand, this person is also not present.
Correct.
Anne Marie can discuss.
Sure. So Dr. Johnson actually has played a lot of roles for the Veterinary Medical Board. He was a consultant for us. He served as an expert witness. He's done hospital inspections, and then most recently applied to be part of our Diversion Evaluation Committee. That committee works diligently with our diversion program in terms of overseeing licensees who are in recovery. So it's a very special role that he fills, and he has some experience in this area, and that's one of the requirements. He's a recovered addict, and he has been tremendous in terms of counseling and helping the Diversion Evaluation Committee make recommendations about those that are going through the program. So I would encourage the board to consider his reappointment.
I would like to make a motion to reappoint Dr. Johnson.
Thank you.
I'll second that.
Okay.
Any discussion? Any comments from the public?
Yeah.
Call for the vote.
Okay. Dr. Waterhouse?
Yes.
Dr. Sullivan?
Yes.
Dr. Nunez?
Yes.
Dr. Nolan?
Yes.
Jennifer Laredo?
Yes.
Kathy Bowler?
Yes.
Lee Heller?
Yes.
And Judy Mancuso?
Yes.
Thank you.
Motion carries. And on to agenda item number 6, proposed regulations. And Anne Marie also will give an update on the status of pending regulations. We do need to make a couple of votes here, and she will explain these.
So we're going to go right through the regulatory item on this agenda, starting with the status of proposed regulations. There's a chart in your board packets, also available online. Animal Control Officer Training is a package that's been working its way through the process. We did have to make some modifications, but the board has delegated the authority of the executive officer to make non-substantial changes. So we will now go ahead and move that regulation package over to the Office of Administrative Law. There was some 15-day changes that were made. They were published. They were really changing some reference sections in the notation and reference authority section of the regulations. There were some subdivisions that the numbering was off, so we made those conforming changes. We'll now move those forward to OAL with, and hopefully have an effective date at the end of July.
Ms. Delmanaya, before you
Yes.
proceed, just want to
Sure.
make sure, I think you and I had done some research and looked backwards in the initial motion. The board did grant you authority to make those technical and non-substantive changes. I just want to verify that at the end of the 15-day comment period of April 3rd, there were no adverse comments.
Correct. No adverse comments related to the language of this package.
Okay, thank you.
You're welcome. The CPEI regulations, Consumer Protection Enforcement Initiative, is a regulatory package the board will consider today, so we'll move into that in a moment. Disciplinary guidelines, the board has seen this many, many times over the last 3 years, and we will see it again today. So that will be another regulatory package. We will be discussing animal rehabilitation, and then it moves on from there for all regulatory packages that have been approved by the board that need to be noticed to the Office of Administrative Law.
Anne Marie?
And
Sorry.
Yeah.
If I may, I just wanted to point out that the summary of the status of the animal rehab sort of leaves off without including the fact that we had a February 2nd meeting and concluded the work of the task force and have recommendations in front of the board today. So it's just, as a technical matter, the information's incomplete.
Okay, thank you. We are moving forward with the RVT education package in that we have started putting together all of the RVT education materials, and that package is up for review. So the board should be seeing that complete regulatory package either in July, we're hoping in July, if not July, October. And then we'll move on with minimum standards in telemedicine. Telemedicine will be on the July agenda to consider some changes that have come out of the National Association, and the board will discuss those changes. Everything at the bottom of the page is all to be determined because the board has not yet made a motion to move any of this language forward. Still under consideration, and the board and the MDC is still conducting research. If there's any questions on any of the packages? Okay. All right, we'll move right into the disciplinary guidelines. I'm going to invite Elizabeth Bynum, AKA Betsy, as we know and love her. She is going to discuss the changes since the last meeting. And again, the board has adopted many versions of the disciplinary guidelines. And at this point, we are now bringing all of these comments and all of these revisions together, and hopefully this is a final work product that we can move to the Office of Administrative Law. There is some handouts before you that discuss what changes have been made since the last meeting to today, and discusses, the memo also addresses language added in 2015 and later deleted in 2017. And the deleted language was based on comments from the last board meeting. We did have input from Lee Heller. We discussed her changes. Kurt Hepler, counsel, actually reviewed the language extensively and made some changes based on his read of what would be most effective in terms of implementation. So that's where we are today.
Good morning, board members and others present. As Anne Marie said, this language has come before you quite a few times, and we're really hoping this is the last time. So what I'm going to do, you should all have the disciplinary guideline language with the most recent changes highlighted in red. I'm not going to walk you through the technical changes like commas and things that got capitalized. I'm only going to go through the substantive changes that, for you to consider. So if you would turn to page 1, the changes on page 1 have been made to use more accurate terminology and more accurately describe things. First, it says the word penalty has been crossed out and level of discipline has been added instead. That's more accurate. We don't really assess penalties so much as levels of discipline. The next sentence says what the board does when an ALJ assesses less than the minimum penalty. In that instance, the board may request that the ALJ fully explain the reasons and the circumstances for the deviation. And then it also later on that page says what happens when the board finds severe minimum standards violations. It does not close the facility, it suspends the license of the facility. So the next change comes on page 3. This is, I guess this is really a technicality. One of the citations was wrong and has been corrected. Now you can flip to page 9 all the way there. And this pertains to cruelty to animals. Because cruelty to animals is a very serious violation, if mitigation is to have any effect, it must be of a significant nature. So we've added that language. The next change comes on page 12. The board is not limited to considering prior actions and deciding whether an assessment of the minimum penalties is appropriate for failure to permit the inspection of records or premises. They can also consider lesser violations that resulted in, for instance, letters of education or citations. And then there's a technical change for better accuracy at the bottom of page 12. Next is on page 14. This is about cooperation with board staff, and the new language specifies that the board will only be seeking the availability of documents relating to the practice of veterinary medicine, not just any documents. Next change comes on page 16. And this change clarifies that during the time probation is told, a respondent must maintain not just any license, but a current and active California license. And then we flip to page 18, where we've made a couple of changes. And one change is that must not, the old language was must not only have, and the current language, it has been changed to shall hold. And this is to be more specific to the requirement of holding a current premises permit. And then the old language was but must also be subject to. This has been changed to, and respondent shall make the practice or location available for inspections by the board, because this is a more specific description of what respondent has to do. And then
I have a question about that. And I've always wondered about that, and not being an attorney, but it makes it sound like if you're on probation, you have to practice in a location that has a premise permit, which the flip sounds like if you're not on probation, then you don't have to have a premise permit.
I don't think that's supposed to be implied.
Again, I'm sure that's, but it just makes it, to a non-attorney, that's the way it sounds.
Anne Marie has a comment.
Yeah, so the typical inspections that we do are random. So this isn't a random inspection. Okay. This is a deliberate inspection because you're on probation. So it is very different than inspections that we do across the board for all veterinary practices. So this is a scheduled inspection, or I shouldn't say scheduled. It is a enforcement inspection as opposed to something random.
Right, and I'm talking more about the having,
right,
necessary of having the premise permit.
Yeah, I think it's just to make it clear that if you are going to operate a veterinary practice, that as a condition of probation, so if you didn't, that would be a violation of probation.
Yes.
Where if you didn't have a premises permit, it wouldn't be a violation of probation, it would be something else.
Yes.
Yeah. So it's in the realm of
Yes.
probation, yeah.
And then at the bottom, premise was changed to premises because the correct term is veterinary premises for what the Veterinary Medical Board licenses. Next, on page 19, we have a few changes. The sentence, if the supervisor terminates or is otherwise no longer available, respondent shall not practice until a new supervisor has been approved by the board. This is not a new sentence. This sentence has simply been moved from the end of this term to the beginning because we think this is a very important point for, that should be noted. And then the term veterinarians has been changed to proposed supervisors. Since this term is all about supervision, we thought that was clearer. And then the language "and have held a valid California license" has been added because it was felt that this should be a requirement of a supervisor. Then later in that paragraph, the words "current or" were added so that a supervisor could not have a current business or personal relationship with the respondent as well as a prior one. That was a bit of an oversight in the old language that we've corrected. And up at the top of page 20, you can see that sentence that we moved. It used to be there, up at the top. In condition 7, no new ownership, the word veterinary has been added to clarify that the board is only prohibiting a respondent from owning this particular type of business, not just any business. The next major change is on page 23. This is another change for greater accuracy. The language "shall result in the old language, I should say, shall result in the automatic suspension from work" has been changed to "shall result in a cease practice order resulting in a period of non-practice suspension from work." This reflects the board's actual practice of effectuating a period of non-practice or suspension from work by the issuance of a cease practice order rather than an automatic suspension. And finally, perhaps the biggest change that was made in this version is that we took the entire overview guide for disciplinary decisions out. It was felt that this overview guide was mainly meant for the board's use as an overview guide to the formal discipline process and didn't really belong in the disciplinary guidelines. The decision was made to relocate this text to the Board and Committee Administrative Procedure Manual because it provides an overview of the Administrative Procedure Act process for the board and outlines a board member's responsibilities in adjudication of disciplinary cases. So I hope those are acceptable changes to everybody.
Thank you, Betsy.
You're welcome.
Any comments? Dr. Nunez?
First of all, the overview guide for disciplinary decisions, that was written by Candace. Is that right? Didn't she write this one?
No.
Yeah. I was gonna give my condolences to Candace.
Oh, I think Candace is okay with it, if I could speak for her. It actually, most of this is already in your board member administrative manual, because it's instructions, so it's there.
Yeah. I always thought it was a little weird that it was.
Yeah.
And it sounds like it's in a more appropriate place now.
Right.
I had a question on the page 9. I definitely do agree that cruelty to animals is a very serious charge. Could you give me an example of what that means, though, by when you're dealing with mitigating circumstances of a significant nature, so something that would somehow relate to why this act was committed, or can you give me an example of that?
I don't know, maybe some sort of explanation saying it was a mistake or my wife divorced me that day. I don't know.
So you can't say, this person is accused of cruelty to animals, but he volunteers at the library every week, and that cannot be used as an example of mitigating circumstances.
No, but I can provide an example. Yeah.
What happened?
So for example, we may get a case where it appears there's a cruelty to animal, and what we find out through further investigation and mitigation and testimony is that the animal was actually aggressive, and so they were trying to protect the staff within the veterinary clinic. And whether their tactics could have been less forceful, perhaps it wasn't intentional cruelty, and that gets vetted out through the case. So there's, those circumstances occur.
Right. Okay. You can't say he was cruel to animals, but he's a really nice guy.
No.
because of what he did.
Yeah.
I beg your pardon, I forgot to go through the two examples of language that was put in the last version and has now been taken out, so that you will not even see these changes in your disciplinary guidelines. So in section 4857, the impermissible disclosure of information about animals and/or about clients, the last version said that maximum penalties should be considered when breaching confidentiality places a client at risk of some form of retaliation. That language was rethought, and now maximum penalties should be considered where there is a breach of confidentiality, period. It was decided that any breach of confidentiality would justify the maximum penalty, not just when a client may be at risk of retaliation. The second place where language was added and then omitted was in optional term 5, inspections. The following sentence was added to the last version but has now been removed from the end of the second paragraph of this term. And that sentence is, if the veterinary practice has 2 consecutive non-compliant inspections, respondent shall surrender the premises permit within 90 days from the date of the second consecutive non-compliant inspection. This language was removed because its implementation would violate respondents' due process rights. Any other questions?
I have one. It's back on page 18, and it's the wording that has to do with the location of a mobile veterinary practice shall hold a current premises permit. The wording to me, when you say the inspections shall be conducted on an announced or unannounced basis and shall be held during normal business hours, the board reserves the right to conduct these inspections on at least a quarterly basis. At least a quarter, that means they could come in every week, they could come, it kind of gives them free rein, and you charge $500 per inspection. So all of a sudden, that seems a little odd to me. Can you, is that?
So this gives the board the purview to come back and inspect as many times as necessary to get someone who's on probation compliant. So it is really important that we're not limited to only inspecting the premises on a certain cycle, because these are people that have been placed on probation for a reason related to minimum standards perhaps, and we're coming back in to check on compliance.
But it also implies that you are going to be, you're going to inspect them quarterly or more, and is that something that you want to be tied to? I mean, are you, if you come in and inspect them twice or 3 times and then decide things are going very well?
No, it says the
at
board,
least,
it says the board reserves the right to, not the board shall.
Okay.
Yeah.
So I think this would be, as enforcement, and the actual enforcement is something out of my realm, but I think this would fall to the discretion of the board inspector and the board staff to figure out the proper interval. If you're compliant, it seems that would necessarily reduce inspection frequency. If you're non-compliant, it seems the opposite would be true.
Correct, and it doesn't mandate it. It's the board reserves the right to. So, and the probation monitor is really the staff person that's taking in all the information regarding a probationer and has their kind of finger on the pulse as to whether or not this is continuing to be a problem or whether we're seeing compliance achieved. Yeah.
I'm just saying, if you charge $500 a visit and you're visiting 12 times a year.
Well, you better get your act straight.
That's more than the fine we would probably charge them. It's doubling the fine. So just mentioning that.
Yeah. Lee Hiller. Thank you, Dr. Waterhouse. These are some follow-up technical corrections, things I think that were missed that were submitted last time. On page 6, at the bottom, we have the same language, or if there are prior violations of the same type of offense. And I think the correction we wanted was achieved on page 12. Prior violations of a similar nature. So remember, this was something that came up in January. I wasn't here, but I was watching from home. about violations of the same offense not being grammatically accurate. So I think if you just substituted the language on page 12 for that, that would solve that problem. Hang on, I've got them all bookmarked here. The other issue, and this happens on page 16, is this issue of respondent failing to engage in the practice of veterinary medicine in California for a minimum of 24 hours per week. That a minimum of is left out. So this also came up in January as you're requiring the practitioner to practice exactly 24 hours per week. So again, it's a technical correction.
16 but not 17, right?
Is there in 17 as well, my proofreading?
No, I'm just saying, you could practice 17 hours.
But it's on page 16. You can practice 25, but not 24, but not 25 hours. Exactly. Thank you, Kurt. Hang on. There was one other. Page 19, second to last paragraph. Item number 3, respondent's maintenance of necessary and appropriate treatment. Would it be prescription of necessary and appropriate treatment? Because you maintain records, as in the next item, but you don't really maintain treatment, do you?
Yeah, Ms. Heller, you're right. There's some noun missing there. Means necessary treatment, or is it? But it's not records, or
I'm not sure.
because it looks like 3 and 4 are.
Can you tell us exactly where we're?
Sure. So page 19, second to last paragraph, third item. So the paragraph begins, respondent's supervisor shall, on a frequency to be determined by the board, and so on. And then there's 5 itemized elements. And they're supposed to assess the medical necessity and appropriateness of respondent's treatment, respondent's compliance with minimum standards of practice in the diagnosis and treatment of animals, and then this is the one I'm flagging, respondent's maintenance of necessary and appropriate treatment. Since it seems like prescription of or implementation would be more accurate, but maybe I'm quibbling over this one.
How about conduction? You conduct a treatment.
Conduct of?
Conduct, yeah.
One is diagnosing and beginning the treatment, and this one is maintaining the necessity.
Yeah, this is one that I'm less committed to changing. The others were more, this is more sort of nuanced.
Okay, Betsy, if I may, has that section been amended?
No.
No.
No, okay.
I mean, I read that as continuation of care.
Okay.
Okay.
Or continuity of care.
Because it's seldom
yeah.
been a case. It's just
Okay, I will withdraw that one.
There you go.
Is it time yet, or no, we asked the
Are
public?
you done, or?
Yes, thank you.
Okay.
When it's time to make a motion, I'm happy to do it. I'm excited to do it.
Any other comments? Any comments from the public?
Good morning, Bonnie Lutz. I reviewed these and I have a couple of comments. On page 15, under notice to employees, you specify registered veterinary employees. And then 2 lines below that.
I'm sorry,
Okay,
before we
sorry.
move on.
Page 15,
Okay.
section 8.
8, got it.
Okay. You have to give notice to all registered veterinary employees. But then below that, it says respondent shall cause his or her employees. Is that just registered veterinary employees?
No, that could be anybody.
Okay, so the notice has to be given to all employees. So maybe we should take out that registered veterinary employees.
I think I agree, yeah, because everybody that works at the practice has to be aware.
Right.
They're under supervision.
Right, no, and
Yeah.
I understand that,
Yeah,
but
okay,
I've always
thank
questioned
you.
that.
I think that's a good comment.
So is there, I'm sorry, just make sure that, so that's on page 15, item 8, the third line down will delete registered veterinary and just say to all employees, is that?
That's what.
Okay.
On page 16, I'm really confused, and since I'm usually tasked with understanding what this means for my clients, I really don't understand how you can define non-practice. First, non-practice is defined as not practicing for over 30 days, but then it's also defined as not practicing for a minimum of 24 hours a week. So I guess I'm just really confused about what this means. Because if non-practice is not practicing for at least 24 hours a week, then that would suffice for over 30 days. That would suffice for anything that was not practicing for over 24 hours a week, which would include if they didn't practice for 30 days.
Well, it
Unless I'm
depends on how
missing
you're
something.
calculating the time. So I think what we were trying to do with the exceeding 30 calendar days is obviously to accommodate people that go on vacation and take time off and maybe out of the country. The second phase of this is someone that practices part-time. What is that defined as? So I think it's trying to make it clear that you can take a break in practice, but if you are returning to practice and you're not a full-time veterinarian, we define practice as something, a minimum of 24 hours per week. So it's more or less, I hear what you're saying, if you're calculating time overall, you could still essentially say, if I didn't practice for a month, but yet I was practicing 24 hours a week, within a quarter, I'm still in a period of practice. I think it's to make it clear for the respondent that you can take a break from practice for normal vacations, illnesses, whatever, but that can't exceed 30 days unless obviously we have some sort of extenuating circumstances, and sometimes we do. This really defines what is a part-time practice that's permissible under probation.
Okay,
Yeah.
all right, thank you. I also questioned the first sentence there on page 16. My question was that they shall notify the board in writing within 15 calendar days of periods of non-practice lasting more than 30 days. Is that a notification before that 30 days starts, during the 30 days, or after the 30 days?
I think it says within 15 days of the period of non-practice.
Right, but is that 15 days before or 15 days after?
I think it could be up to 15 days after. It's within 15 days. That's the way I interpreted
agree.
this.
Return to
Yeah,
practice.
yeah.
15 days.
Okay, so it could be before or after?
Right.
Okay.
Is that what you read it to
Yeah,
mean?
exactly.
I think that's how we apply it. I don't know if Candace has any further comments. Betsy? Okay. Candace, do you have any comments on the within 15 days? So we're talking about a
Tolling of probation, when they have to notify the board of any periods lasting more than 30 calendar days. Sure.
is that 15 days before the period of non-practice, or could it also be within 15 days of non-practice? So essentially, we don't require them to notify us 15 days prior to leaving. It could be before, it could be during. Correct. I think the within provides that flexibility.
Okay, thank you. Okay, just one question on page 17, section 14. Is staff still able to make provisions for payments of the costs? Okay, thank you. Page 18, section 5, and Dr. Waterhouse questioned, I had the same question about having to have a permit, because my clients always ask me this question. It does appear, and I understand what you said, Anne Marie, except that wouldn't the obey all laws cover that without having this written in? Because it's really always very confusing, and my clients go way off trying to figure out what this means, and it really just means you have to have a premise permit.
Correct.
But wouldn't obey all laws, which is always included as a standard term, cover that necessity to have the premises permit?
For everybody that knows what that means. So I think we're talking about, you're very informed with the Practice Act, and those of us in the room, most of us are fairly familiar with all laws, obey all laws. Again, this is really notice to the person that's a probationer, who may or may not be represented by counsel. It's so they understand what their obligations are under these specific terms. I hear what you're saying, it's duplicative. I would rather it be duplicative so that the probationer has a clear understanding of the expectation.
Well, then, I would just suggest, could we have some kind of language in here that says, that says that everybody who practices veterinary medicine has to practice in a facility that has a premises permit, but this is just to remind probate. I just find it's always an issue, because this term is always included, and it makes the clients spin on whether they always need to have a premises permit if they aren't on probation. So could there
What
be-
might help is if we reference the code section. So as provided in 4853, you know, respondent shall, and then go through that way. So they know it's a current provision of law.
That's great.
Would that help?
That would be
Candace, are
great.
you comfortable with that? Okay.
Okay, page 19, regarding the supervisor, I know that you're aware that this is a real problem for people to be able to get a supervisor, and I certainly am not arguing with the provision that they have to. But I really think it's a bit onerous to say that if the supervisor stops supervising, that veterinarian has to stop practicing right away, because my experience has been that a lot of these supervisors are a little bit, they can be flaky, and they sometimes just up and quit, or up and don't show up. And that puts a lot of burden. It seems to me like there should be a number of days, or maybe, 2 weeks or something, for them to get a new supervisor, if their supervisor just up and quits, because that puts a lot of power in the hands of that supervisor.
I mean, that would be a board decision. It's a current provision of probation to be under supervision. Any time period that you're not under supervision, technically you're not complying with that term. I hear what you're saying from a logistical perspective, but I also struggle with providing periods of non-supervision for a term that's been enforced by the board.
Right. It's been my experience that, in this case, Jazzpreet, though,
Yeah.
they're able to sort of work
We do.
within that. Okay, all right.
And we make every effort to respond to those requests as quickly as possible.
Great.
Well, I think-
Sometimes same day.
I think
Great.
staff is vigilant. I would just say, my experience has been, as not to repeat myself, but I would have to say, what's the consumer protection obligation here? And if it's ordered probation with the supervisor element, then I think that, and I would respectfully also say, doesn't the respondent / probationer pick his supervisor?
They do, and they submit that to the board.
Correct. So I understand the comment about being flaky, but, you, just like kind of marriage, you chose that person to be your supervisor. So,
The problem is, there aren't a lot of people who want to do that job.
Correct.
So that's really the problem, is that a lot of veterinarians don't want to be supervisors because they're afraid that if they become the supervisor, then the veterinary medical board is going to go after them for
Correct.
something. So that's what I hear all the time.
Right.
I know you've never done that, and that's what I tell them, but that's the comment.
no, it's liability running uphill, right?
Yeah.
So-
That is a concern that is often.
Candace, can you talk into the mic because it won't be picked up?
That's a concern that's often conveyed to us by the probationer, but in reality, in the implementation, we haven't seen it to be a true.
Which concern, not that we're going to go after the supervisor, but
No.
that thank you. We need to clarify that
Not
for the
that,
record.
But that there's, an undue burden, so to speak, on the probationer to find a supervisor.
Yeah.
On page 20, section 8, I just want to verify that there is the possibility of variance from that under certain circumstances. In other words, oftentimes we'll carve out that they can continue to have, be the managing licensee for their current facility. So in that case, should you add new there, or do you want to leave it the way it is with the ability to negotiate
Candace, do you
that?
want to address it?
With regard to terms 7 and 8 for the no new ownership and adding that was something that when we had the task force, they felt like that was something important to add there. We did consider that with regard to no management, and felt like that wasn't appropriate there. It doesn't change the fact that in a stipulated settlement, we would still be able to have that flexibility.
All right, thank you. I just didn't know by changing these guidelines if we were losing the ability to negotiate some of those terms, so.
So just to be clear, we're not changing. This one was already here. The only thing we took off is or be an administrator because no one really knew what that meant. So it was a term that was there. We just took off or be an administrator because that really didn't apply.
Right, no, I understand that. You added veterinary, and I understand why
Yeah,
you added
yeah.
that, but. then on page 23, you've listed ethics training, but there's nothing in here about other continuing education. And I'm seeing frequently that that's added.
I'm
So
sorry.
there's not a term that calls for other continuing education other than ethics training. But I'm assuming that,
I think there is, but it's on another page. Page 20.
Oh.
Yeah, provision 9 is general continuing education.
sorry, I just didn't see that.
That's okay.
Okay. All right, that's all I have. Thank you
Thank
very
you.
much.
Bonnie, before you step away, if we might revisit page 15 when it talks about notice to employees, and you had the concern versus registered versus unregistered. Just from a monitoring standpoint, it's very, very difficult to monitor all employees notified because those that aren't registered with the board typically are pretty transient. They come and they go. And the reason that we were looking at the registered is because those are individuals who hold a permit with the board. And we felt like they have something to lose if they're, say, for instance, working with someone who is under supervision. They have a right to know that that person is on probation for whatever reason. So that was why there was a distinction there with registered. If you want to remove it, that's fine, but I just wanted you to know that in implementation, as far as, tracking notification to all employees, that becomes much more difficult.
Agreed, but I think where we would want the registered veterinary employees is shall cause the registered employees to report to the board, because those are the only people that we could cause to report to the board. Giving notice to all employees, in my experience, is very appropriate and consistent with what other probation monitoring entities do, because the employees at that location should know that there is an enforcement order pending or an enforcement order that's been adopted. It's where we cause these employees to notify the board. We can't cause someone who's not licensed or registered with the board to notify us. So perhaps instead of just removing it from notification, we move that to respondent shall cause registered veterinary employees to report to the board. Does that seem?
I think that sounds like a logical resolution.
Yeah, so we can apply that.
And I just want to confirm, and remove in the line above it, registered employees. So they still have to notify all employees. Right, got it.
Yeah.
Okay, that makes sense.
Thank you.
Thank you, Bonnie.
Any other comments from the public?
So, members, I know that Ms. Mancuso is eagerly anticipating a motion. As I've said before, the regulatory process of Consumer Affairs has changed just a bit in that we now submit the initial rulemaking documents to both the department and to agency for their review, and then if there's no adverse comments from either of those two agencies, then the matter is noticed. So any motion would be that we authorize the executive officer and her staff to prepare the necessary rulemaking documents, submit that to the office, to the agency, State Consumer and Housing Agency, and to the department for review. In the absence of any adverse comment, then have those published.
So Judy, would you like to do that?
Yes, as he said. I am so thrilled that we got this disciplinary guidelines done once again, and I think that the staff has done a great job, and so has the board. I think this has really improved the disciplinary guidelines.
Is there a second?
I'll second.
Come on, I've only been working on it for like 100 years with you guys. Okay.
Okay, any other discussion? Any other public comment? Okay, you want to call for the vote?
Sure. Dr. Waterhouse?
Yes.
Dr. Sullivan?
Yes.
Dr. Nunez?
Yes.
Dr. Nolan?
Yes.
Jennifer Laredo?
Yes.
Kathy Bowler?
Yes.
Lee Heller?
Yes.
And Judy Mancuso?
Aye.
Thank you.
Okay, on to agenda item 6C. So now we discuss the consumer protection enforcement.
Betsy, can you remain at the table just in case I have questions?
Sure.
Thank you.
On CPEI?
Yeah.
Let me grab my stuff.
Okay. All right, well, sure, Dr. Waterhouse, would you mind if I just briefly explain what we did here?
That would be wonderful,
Okay.
yes.
So briefly, because there's no need to belabor this, you've seen this before, and you did approve language. As things go, when you have a number of attorneys that get in a room and all look at something, they all have their unique spin on how it should read. So our very competent and esteemed counsel took another swing at this and asked us to make some conforming changes so that this language reads clear, it would be legally defensible. It really doesn't change the intent that the board approved originally back in 2014. It essentially puts the language in the appropriate code sections of Code Section 2003, which is the delegation and functions of your executive officer. Like I said, content, the board had already delegated to the executive officer to approve settlement agreements for surrenders or for interim suspension orders because of their significance in terms of the immediacy that we need to do something to effectuate basically a cease practice order or surrender for a limited period of time until we can have our day in court. Compelling an applicant to undergo a mental or physical examination for fitness. This is something that we could do by order by a judge. There's a provision in Business and Profession Code Section 820 for licensees. This now gives us the authority to do so for applicants. And finally, the grounds for discipline that you approved back in 2014, renamed the code section so it more accurately reflects what we're trying to do here. And really, this talks about failure to report things like convictions and convictions of felonies or misdemeanors or any disciplinary action taken by another licensing entity or authority. So from a substantive perspective, the board has already approved the language. We reordered it. Kurt finessed some of the terminology, and that's what's before you today.
We have to vote on it again?
Yeah.
So yes, we need to vote on this again. So does anybody have any questions?
Members, I just have a comment.
Of course.
Your competent counsel isn't here today, so you're
stuck with you.
You're stuck with me, right? So there's just on the proposed language, Ms. Welch has a few suggestions. I don't know that they're exactly warranted, so I'm going to leave that aside. There are a couple things like under the authority cited under each section for the Code of Regulations, we would have to underline it.
Yeah.
That sort of thing. For those, other than that, the motion would be, since we have not noticed these yet, the motion would be similar to the one that we just passed with respect to the process.
Correct.
So moved.
Is there a second?
Second.
And just that's, members of the audience and other members, this is the motion to prepare the necessary rulemaking documents, submit them to the agency and to the Department of Consumer Affairs in the absence of any adverse comments and any train horns. Then they'll be published with the notice and published with the Office of Administrative Law.
Any other discussion? Any comments from the public?
Okay.
Should we call for the vote?
Thank you. Dr. Waterhouse?
Yes.
Dr. Sullivan?
Yes.
Dr. Nunez?
Yes.
Dr. Nolan?
Yes.
Jennifer Laredo?
Yes.
Kathy Bowler?
Yes.
Lee Heller?
Yes.
And Judy Mancuso?
Aye. Motion carries.
John?
So on to agenda item number 7, report from Dr. Klingborg on the MDC.
Good morning. You should have a report in front of you that's a quick summary of what we discussed yesterday, and I'm going to run through that with you.
Excuse me, we don't know where the report is right now.
Should say MDC report. It's one page.
That's right.
Oh,
Okay.
this one.
Right after that.
Okay, got it. We thought it was on the table.
Perfect.
This one.
So our complaint process audit subcommittee continues its work. They just participated in Oh, by the way, I'm Dr. Klingborg, Chair of the MDC. Sorry for not introducing myself. Our Complaint Process Audit Subcommittee it's an ongoing subcommittee that's looking at complaints and also participating in expert witness training, and they most recently did participate in expert witness training within the last week or so. It's not the first time they have participated in that. And they will be doing one of their semi-annual case reviews before our next meeting, so we will hear back on that at that time. We had a discussion and consideration of extended duties for registered veterinary technicians. We had asked CARVTA to give us some more background. CARVTA a couple meetings ago had presented a list of tasks that should potentially be excluded to DVMs only or DVMs and RVTs only. And so we had that list. You have that list. That list made its way to the MDC. And then we asked CARVTA to actually expand upon that and give us a little bit more information. Questions such as, does this particular procedure involve surgery, suturing? What are the access and need issues? What's the risk of harm? CARVTA also included what's happening in other states and some language about the RVT curriculum. It's a lot of data to kind of sort through, and we're still trying to find, I think, our way around all of these various tasks. We're aware that there have not been a lot of tasks added over the last 20 years for RVTs. And so the idea now is for this to move into a subcommittee that will start to work through that. I will be assigning that subcommittee and have reached out to a couple members of the task force or of the MDC, but we have not formalized who those folks are at this point. I do thank CARVTA for their help. They prepared a very nice document that gave us a lot of useful information. The next agenda item was review legal counsel's guidance on the Federal Drug Mobility Act. This was really more of an FYI for us. The Drug Mobility Act, there's been an interpretation of that it does exempt an RVT from being required to be registered with the DEA when she or he administers, dispenses, or transports controlled substances under the direction of while in the employment of a veterinarian who is registered with the DEA. That is my understanding of that. I don't know that I understand it any more than what I just said. And so that would be something that we would ask legal to illuminate us on at some point. But again, this was just kind of an FYI about that. Discussion and consideration of recommendations from SHAC and CVMA regarding public and private shelters. Their work is ongoing, and so we did not have any work product at this meeting to discuss as we had hoped. We do expect to have something at our next meeting, and CARVTA is correct. I did ask in meeting last time that CARVTA would be involved in those discussions as well. So we want to get as many perspectives as possible. Review and consider proposed regulations regarding the compounding of drugs. The subcommittee of myself and Dr. Sullivan, along with Anne Marie, the two of them were in Sacramento talking with Board of Pharmacy last week, and I teleconferenced in. Very good discussion as we continue to try and get our way through understanding and just achieving some accord with Board of Pharmacy about how we allow specifically for sterile compounding in the clinic setting. We're not looking for veterinarians to become compounding pharmacies and start selling the stuff to their colleagues around the street. It's a very narrow focus that we're looking for here, but it is to allow us to do what we need to do and have been doing for decades for the safety of our animal patients. And again, a big step forward this last week, and so I think we're actually getting much closer to where we need to be with that. And that's only taken a year and a half. So
Great. Fast track.
Let's see, discussion and consideration of proposed amendments regarding drug information to be provided to clients. We had some draft language. Doctors Pollard and Sullivan did a great job of putting together some draft language and a platform for what some of that drug counseling might look like. And it's built on the same platform of what pharmacists are expected to do when they counsel humans for whom they prescribe products. But it's a work in progress. We realize that what we have in our packet is not perfect, and so we're still working on it, and we'll meet back again and talk about it at the next meeting. Discussion of the scope of responsibility for induction of anesthesia versus sedation. This is really a very strange agenda item in that what it started out being was a discussion about the shelter setting and when animals had some sort of urgent need to be sedated and or anesthetized so that we could deal with the problem. And problems that we talked about in the shelter setting, and they're not unique to the shelter setting, but it would be the cat that's so badly matted that we know that there's infection underneath the skin, and they're in pain, they're suffering, but we can't touch them. We need to sedate them. Or the husky that has decided to grab a hold of the cage and now has his teeth stuck on the cage, and we're not going to be able to remove him from the cage, his teeth, until we've sedated him and get him to relax. And again, not unique to the shelter setting. And so we kind of walked back from that conversation yesterday as far as shelter setting and started to talk a little bit more about these emergency situations and that are not necessarily life-threatening but are serious. And so we've got this 2069 language, which is our emergency language, and 4840.5. And so we've got some language in there, but we need to have something else, we feel, that helps us pick up the phone, the veterinarian pick up the phone when the RVT is called and said, we've got this problem happening right now. What can we do about it that may authorize some level of sedation? What we need is we're asking for permission to have a subcommittee to look into that concept. So this whole induction of anesthesia and sedation thing is now off the table. We have dispensed with that, but that's mutated now into a request for a subcommittee. Discuss minimum standards for spay-neuter clinics. We of course have fixed veterinary practices. We have mobile practice minimum standards, and we have small animal vaccine clinic minimum standards. So at some point, we thought it might be a good idea to look at developing spay-neuter clinic minimum standards. And so the information's been there for a while, but we've had a lot of work to do. So we finally got a chance to talk about it yesterday, had a great discussion, and decided that the fixed premises language that we already have there is fantastic. It really just is up to the hospital inspector to have the latitude to know which sections to apply or to not apply. And so rather than reinventing the wheel, we thought that we were better just saying, hey, we've already got language, and let's work with what we know does work. So that was a no action. Discuss minimum standards for mobile specialists. There's been some difficulty when a specialist comes in and performs a procedure, and then the specialist exits and the animal patient isn't responding in the way that was anticipated. Who's ultimately responsible for that? Is it the veterinarian that established the VCPR? Is it the specialist who came in that may or may not have communicated with the client? And the bottom line, Dr. Bill Grant was the subcommittee on this, and is that there's no bright line. As he said, when there's two or more veterinarians working together on a case, we just can't clearly delineate who's responsible. Unfortunately, when there are complaints, there is the process that we have, and that does typically determine who is at fault when there are shared cases. But we really could not develop any language that made it any clearer when a veterinarian's responsibility or what it was to the client at this point. So we, again, had that discussion and felt that everybody ought to know kind of what they should be doing when it comes to the animal patients. Review, discussion, and possible recommendation on reciprocity issues and license eligibility. So the MDC picked up a conversation that you had at your last meeting, and this was a conversation about whether or not board certification could serve as some sort of proxy or in lieu of practical clinical experience when determining reciprocity. And the board had added some language to that section 4848B1, which basically said the intention was for that practical experience to be within the United States, a U.S. territory, or Canada. The way that it was written had not made that clear. But the next step then, the next part of that conversation was, does board certification excuse any of that criteria, the number of hours that one needs to have practiced in order to get reciprocity? And as the MDC looked at it, we felt that board certification should not be considered in lieu of practical experience. We're not limiting these individuals' ability to go practice in the state that they're already licensed, and felt that there should not be special consideration there. Once that happens, and you allow board certification to serve as some sort of proxy, well, this group is not in charge of board certification. You're now putting your standards and hanging them on some other group, and the board certification process does vary depending on which board you're talking about. And so we said no, we don't think that's the right place to go. That was our meeting in a nutshell.
Thank you.
Thank you.
Thank you for all your hard work. But are there any questions? Yes, Dr. Nunez.
In regards to the minimum standards for spay and neuter clinics, you have that there's already a list of standards on the inspector's checklist for a fixed practice, and certain items would apply to a spay and neuter clinic, and you say that the inspector should have the flexibility to apply. So that would imply there's certain things that a spay and neuter clinic doesn't have to comply with, that the inspector doesn't need to check that off. But is that something that's going to be standardized amongst the inspectors? It's up to the inspector to decide which one to check off and which one doesn't have to be checked off?
Yes, the feeling was it's up to the training to help the inspectors recognize the leeway, because practices, what we heard yesterday in testimony was practices are more different from one another than the same. There's a lot of different ways to do what we do, and to try and create standards for every flavor of a veterinary practice, this would be an endless loop.
But would that potentially lead to like a spay and neuter clinic passes depending on which inspector they get, if there's not uniformity to what that inspector's going to be looking for?
Well, it shouldn't. I mean, I don't know. One example I think would be X-ray, radiology provisions and things of that sort. And if you don't have an X-ray machine, then that's probably not going to be pertinent. And so it should not. The training should resolve that.
Right. Although I would agree with that, what if there's an inspector that believes that an X-ray machine is needed? If it's not properly
well, I think that's
out to them what is going to be needed in a spay and neuter clinic.
So let's say that happens, and so then somebody gets a little fix-it ticket, a little check on the box in their inspection. They have the individual veterinarian, the managing licensee, at that point has the ability to respond to that, right? I mean, they have the ability to then say to the board, hey, wait a minute, this is why this shouldn't apply to me.
And maybe Anne Marie can discuss this.
So that's not uncommon, and that's why it's not the determination of the inspector after the inspection to decide what is non-compliant. The staff does that. So the inspection reports come in and say, for example, and this happens often, there's something marked as non-compliant. And then we request a response from the MGL. They have 30 days. And their response will say, we don't do on-site x-rays, we send it out. Then the staff would notate, not a compliance issue because they've satisfied that they should not have to meet that standard. So it's pretty common that we do that in-house, and we do it pretty much with every IR report, inspection report we get in. We do train our inspectors that not every situation, all standards will apply, because if they don't practice that type of medicine or that level of medicine, a perfect example is something we've been dealing with in our task force with the CVMA, which is anesthesia-free dental. If that's all you did in your veterinary practice, not third-party location, obviously we wouldn't be looking at surgical suites. We wouldn't be looking at certain, perhaps, drugs that you wouldn't otherwise have. So it just depends on the variation of the practice, but we do include that in our training, and actually that's a substantial part of our training.
So then really puts a lot of that emphasis on the training, on how to apply the standards for these different practice steps.
Yes.
So is there going to be some sort of written training protocol to?
There is, yeah.
And that's where most focus is going to be on. Is that produced by the MDC, or is that something that's?
No, we have a training protocol for all inspectors, and that training protocol continues to evolve. So as we identify what we consider hot topics, gray areas, that's incorporated in the training, and there is a written training manual for inspectors.
Okay. Yeah. And there would be a section saying when you're inspecting a spay and neuter clinic, these are the things that you should be looking for.
I can't say that specifically it says spay and neuter clinic, but it does say if you're inspecting a practice that does not include one of these, following areas, you wouldn't be applying these minimum standards to that practice.
Any other questions? So we have two motions here. One is a motion to accept his report, if I can have somebody so move.
I'll motion that we accept Dr. Klingborg's report.
It's been seconded. Any other questions? Any questions from the public?
Can I add a
Comments?
stipulation that we also give them permission, or is that?
That's
That's the second motion.
part.
Who
was gonna
seconded
try
that
to-
motion, please?
Kathy?
Kathy?
Okay.
Just gonna try to kill two birds with one stone.
Can you even call for a vote?
Did you have a question, Dr. Sullivan? Okay. Okay. Call for the vote to accept Dr. Klingborg's report. Dr. Waterhouse?
Yes.
Dr. Sullivan?
Yes.
Dr. Nunez?
Yes.
Dr. Nolan?
Yes.
Jennifer Laredo?
Yes.
Kathy Bowler? Lee
Yes.
Heller?
Yes.
And Judy Mancuso?
So the second motion would be to go to 7A for the existing priorities of the MDC. And so we're going to remove 7, 8, and 9.
So under tab 7A, there is a list of the MDCs. Under tab 7A, Judy, there's a list of the MDC's existing priorities. I believe items 1 through 6 are still in play, with a slight modification of item 5. It is no longer a sedation versus anesthesia discussion. It is really more about protocols for emergency situations where RVTs may use sedatives, and that is California Code of Regulations 2069, 40, and Business and Profession Code Section 4840.5. I believe the MDC, correct me if I'm wrong, Dr. Klingborg, has satisfied their discussion. Item 7, development of minimum standards for spay and neuter clinics, minimum standards for mobile specialists, and finally discuss equivalency pathway for reciprocity.
Yes, those are done.
Okay.
So then, Ms. Delmanile, I guess with number 5 then, the sedation versus anesthesia is, dichotomy is now a little bit obsolete, and we're moving, I think, the NBC moved yesterday to more of a global consideration of the regulatory section 2069 and the statute 40.48, 40.5, see whether those needed to be amended
Correct.
to reflect perhaps the current state of practice and consumer protection. I think MDC was also looking for the authorization to form a subcommittee, if I'm not mistaken.
Yes.
Agreed,
Is that correct?
although I believe the chair of the MDC has discretion on formulating a subcommittee of his members. Is that not correct, council?
I'm not currently aware of the delegatory power down to MDC, so if that is so constructed, then we don't need that.
I can't form one unless it becomes a priority for the
Right.
MDC.
So we need the board to establish the priority, but Dr.
Yes.
Klingborg may, in his duties as the chair,
Certainly.
assign this to certain members of the committee.
Understood.
Okay.
I don't want to be redundant, just redundant.
So do we have a motion?
So moved.
Second? Any other discussion? Any comments from the public?
Okay.
Call for the vote?
Dr. Waterhouse?
Yes.
Dr. Sullivan?
Yes.
Dr. Nunez?
Yes.
Dr. Nolan?
Yes.
Jennifer Laredo?
Yes.
Kathy Bowler?
Yes.
Lee Heller?
Yes.
And Judy Mancuso?
Aye.
Motion carries.
Thank you.
And let's take a 15-minute break. So we will reconvene at, 11:40.
Members of the audience, for the upcoming issue.
We're on to agenda item number 8. And we anticipate there may be a lot of people to speak on this topic. And so we can tell you right now that we'll probably have a time limitation, we will have a time limitation on each speaker. But first, we're going to have a report from Dr. Nunez and Dr. Klingborg on the result of the Animal Rehabilitation Task Force.
So my opening statements are going to be similar to Admiral Stockwell in the vice presidential candidate with Ross Perot. Who am I? Why am I here? The answer to that question at our last sunset review hearing in March, one of the requests that was made by the legislature was to create a animal rehabilitation task force. And the legislature would with the charge of this task force being responsible for creating provisions for regulating the practice of animal rehabilitation. And one of the first things that we did to create this task force was to establish the composition of the task force to represent all the various stakeholders that would be associated with this practice. And the task force was made up of 2 members from the Veterinary Medical Board, which was myself and Lee Heller, a representative from the Multidisciplinary Committee, Dr. Klingborg, and we also had representatives from the California Association of Animal Physical Therapists, the California Registered Veterinary Technician Association, the Academy of Physical Rehabilitation Veterinary Technicians, Western University of Health Science College of Veterinary Medicine, Northern Association of Equine Practitioners, California Physical Therapy Association, Certified Animal Rehabilitation Therapist, California Rehabilitation Institute, Certified Veterinary Acupuncturist, University of California School of Veterinary Medicine. We also had 2 consumers on the task force, Bill Gage, the Chief Consultant for the California Senate Business Professions and Economic Development Committee, and a representative from the California Assembly Committee on Business and Professions. So we felt that that was an accurate and fair list of stakeholders. An invitation was sent out in May to invite, the invitation basically went out to the stakeholders, and we thought, in order to be fair, the stakeholder groups would decide amongst themselves who they wanted to send as their representative. And that was how the task force was formulated. We had our first meeting in June, and the first meeting was pretty much a review of the objective of the task force, a review of the mission of the Veterinary Medical Board. Kurt Hepler, our legal counsel, gave a lecture about statutes and regulations. It was very boring.
So gracious.
That's not the first time that's been said.
And then we pretty much got to work. Really what it came down to was the actual definition of what physical therapy was and who would be able to perform physical therapy and where they would be able to perform physical therapy was not specifically written in the Veterinary Practice Act, and there was also no language in the California Physical Therapy Practice Act about any of this. So this was not an attempt to write any particular pieces of legislation, but it was just some recommendations that can be used as a springboard to start to go down that path. So we were supposed to get this accomplished in 2 meetings, and at the last minute it was extended to 3 meetings, and there were some motions that were agreed upon by the task force at each of the separate meetings, and if the president agrees, I thought it would be good to go through each recommendation individually and then have a discussion and a vote on them, if that's appropriate, if that's all right with you, or how we can proceed.
Yes, so we plan to go through each one individually.
Okay.
Yes.
So at the first meeting, the first recommendation was to pretty much define what rehabilitation is and what it is not. And the recommendation was that animal physical rehabilitation is defined as the treatment of injury or illness to address pain and improve function by means of physical corrective treatment.
Should we have them give their report?
Yeah, we're going to go ahead.
Yeah, okay. So why don't you just go ahead and give your whole report, and then we'll start over with
All right.
recommendation number 1 with the
Okay.
discussion and voting.
Okay. So,
And I also should say that we plan to break for lunch between 12:30 and 1:30.
okay. So, obviously, this was, if you're going to be writing legislation and regulations, you want to know exactly what it is that you're regulating and what it is not. So the second recommendation was animal physical rehabilitation does not include relaxation, recreational, or wellness modalities, including but not limited to massage, athletic training, or exercise. The task force thought that this would definitely be too wide of a field to include a massage or exercise, especially with racehorses, because you have to remember that this isn't just massaging the kidneys or anything like that. It also includes like racehorses and things and so forth. There's already some regulations that's currently in the Practice Act, the Veterinary Practice Act, that we wanted to point out was in there, and that none of these regulations would apply, which was number 3, any proposed changes to existing law and regulations are not an attempt to restrict or amend section 2038 of the California Code of Regulation regarding the provision of musculoskeletal manipulation modalities. And specifically, this is a reference to the chiropractic provisions that are in the Veterinary Medical Practice Act. Recommendation number 4, prior to performing or authorizing animal physical rehabilitation, a veterinarian shall establish a valid veterinarian client-patient relationship as defined in sections 20321.1 or 2032.15 of the California Code of Regulations. And again, this was, we agreed that it was important for a diagnosis be made by a licensed veterinarian on an individual patient. And with this diagnosis, there would be a prescription of treatment for rehabilitation. We thought that that point was very important to be maintained. That really was pretty much the groundworks, the foundation of defining what it is not, and also the real strong importance that it's the practice of veterinary medicine. The condition had to be diagnosed and a prescription for treatment needed to be made. Then the real challenging part of this started to come at the next meeting, where we pretty much identified the separate groups that were going to be performing physical therapy. And those groups were veterinarians, registered veterinary technicians, veterinary assistants, physical therapists, and physical therapy assistants. And what we decided to do was to, among all those 5 groups of people, determine if they were, if they had proper education and proper training to perform rehabilitation, under what circumstances would they be allowed to perform physical rehabilitation, and eventually in what locations or situations they would be able to practice physical rehabilitation. We started with the veterinarian side. The first recommendation was that veterinarians have sufficient education and training to provide animal physical rehabilitation. We had some presentations from representatives from both universities that discussed the training and education that they receive. There was many questions and discussions on that, and in the end it was determined that veterinarians do have that education. Yes.
So just quick commentary here. This is where things did start to get sticky with the task force. All 50 states and around the world, animal physical rehabilitation is accepted as the practice of veterinary medicine. But just kind of the flavor of this task force, it took us 3 hours of discussion to pass this discussion, or to pass this particular motion, and that was by a 10-8 vote. So we were very contentious at this stage, trying to move forward and provide some guidance to the board.
Yeah, Dr. Klingler made some reference to the material that was available to us, because I would say that the task force was impressive in the amount of material and the amount of research that was put into this. With I think we determined that we could not print out all the information that we had available to us, and we eventually went to hyperlinks on the interweb to access things. But there was examples from most 50 states about how they deal with this issue. The second recommendation on that meeting was that registered veterinary technicians may provide animal physical rehabilitation under the direct supervision of a veterinarian, unless in a range setting, in which case the veterinarian may provide the appropriate level of, I suppose that should have been determine the appropriate level of supervision. So this was in regards to, that was just an issue of access to this rehabilitation in a range setting, that it might be a little bit unrealistic for the veterinarian to be present in those cases.
And this motion passed by the widest margin of the day. It was a 14 to 3 to 1 vote. So there was wide consensus that, and recognition that RVTs are skilled providers of various health care tasks for animals. And the overwhelming majority of this task force was in agreement. The direct supervision in the small animal setting was most appropriate for patient and consumer protection.
And then the third recommendation was in regards to veterinary assistants. Veterinary assistants may provide animal physical rehabilitation under the direct supervision of a veterinarian or an RVT. And that pretty much rounded up the veterinary team aspect of who can perform physical therapy and in what situations.
And it was noteworthy here that all but one of the veterinarians and all of the RVTs on the task force did vote for direct supervision, again, the highest level of supervision for these individuals.
What was the vote breakdown on that third?
The vote on that was 10 to 8.
Yeah, sorry. I don't know if I was the only one confused by this, but in number 2, a registered veterinary technician has to be under the direct supervision of a veterinarian, but in number 3, a veterinary assistant can be under the direct supervision of a veterinarian or an RVT. So if I'm being directly supervised for a veterinarian, how am I going to directly supervise a veterinary assistant? It was confusing to me.
Yes.
No,
Before we answer those, dive into, why don't we allow the two gentlemen to conclude their report, and then we can dive into, by my math, the Elite Eight.
Okay. So that the October 4th meeting was held at the Capitol in one of their majestic meeting rooms, and we were supposed to finish the task force at that meeting. I asked somebody to take a picture of me in that meeting room because I thought it was impressive. No one did.
So there's
I'm
no
just
proof
saying.
it happened?
You can Photoshop.
There's proof that it happened, but I would have liked a picture of me leading that task force. I'm just saying.
We've got 6 hours of webcast for you to
Yeah. You can do a screen capture.
Not the same. So after we went through the veterinarians, the registered veterinary technicians, and the veterinary assistants, we had maybe about 30 minutes or so to try to get through the physical therapist and the physical therapy assistants. And I attempted rather pathetically to get through them. And Bill Gage graciously extended the timeline at the last minute. And that's when we went to the February meeting where we started to tackle the physical therapist and the physical therapy assistants, and pretty much we tried to go through the same process to have representatives from the schools on what their curriculum is like, how they're trained in physical therapy, and also how they're trained in physical therapy specifically related to animals. And the recommendations that came from that final meeting was that California licensed physical therapist with advanced certification in animal physical rehabilitation. In other words, after they've completed their regular physical therapy program, there's also an additional certification, advanced certification program. And then parentheses, with such certification to be defined by the Veterinary Medical Board and Physical Therapy Board working cooperatively, may provide animal physical rehabilitation under the degree of supervision to be determined by the veterinarian who has established a veterinarian client-patient relationship on a veterinary premise, or an animal physical rehabilitation premise as defined in regulation by the Veterinary Medical Board and the Physical Therapy Board working cooperatively or a range setting. That's a really long sentence, I know. But the points that I would like to emphasize on this recommendation is that the concern that the veterinary community had was that the physical therapist didn't have enough training in physical therapy specifically related to animals. And there was also a concern that they would not be able to recognize, they weren't trained to recognize certain medical conditions in the animal patients, and therefore it would pose a risk to them. So the concession that was placed in this recommendation is that that advanced certification, that additional training, is going to be overseen or defined by the Veterinary Medical Board in cooperation with the Physical Therapy Board. So it does allow the Veterinary Medical Board to make sure that this advanced certification does properly train these people who are going to be performing physical therapy on animals to recognize certain risks, certain conditions that may put this pet at risk. So just as the Veterinary Medical Board ensures that our veterinary schools teach what we feel is important for veterinarians to know, and just as this board ensures that the RVT program teaches those students what we feel is important for them to know in order to protect animals, this board does have the ability to ensure that this advanced certification program ensures that those physical therapists that are going to be performing services on animals know the things that we think are important for them to know to ensure that no harm is done to these pets. That provision allows the Veterinary Medical Board to do that. They can't just go and create a program on their own. And it also is going to be in conjunction with the Physical Therapy Board, which I think is working together with other boards for a common good, I think is always a good thing. I know, I'm going on. The other point that I would like to make, just to emphasize, is that in regards to the location of the place, it does have that, and this was also the really big point of discussion, was that physical therapy can be practiced at a location that does not hold a premise permit. In other words, it's not a veterinary hospital setting or any other place that holds a permit like that. But it says the premise permit, if the physical therapist can have a premise, but that premise is as defined in regulation by the Veterinary Medical Board and the PT Board. So in other words, there could be places that physical therapy is performed that does not have a veterinarian, but that place, per this recommendation, it should have a permit. There's a lot of complicated things that are going to come up, but that was the intention of the recommendation that was made.
So, little commentary on that.
Well, before we begin, I just want to, so my theory of how we should proceed would be, at the conclusion of the report, which I'm drawing near, and I think the board should entertain, if it so wants, a motion to accept the report, not accept any recommendations, just get the report before the board so that it can tackle the recommendations contained therein. Okay? So I do want to, at this point, I do want to clarify, Dr. Clemmer, I'm going to let you proceed, but at the end, before we begin, there seems to be, I want to sort of inoculate the jury on this document that came before it was attached to your packet, because I think there may be a few misconceptions about going forward what that document, I'm talking about this is Animal Physical Rehabilitation Act of 2017 concepts, what that document stands for and what it represents, and maybe it doesn't really stand for all that. So again, after Dr. Klingberg, after you proceed, I think the board should entertain a motion to accept the report, not pass judgments on the merits of any any recommendations therein just for the purpose of getting it before it and then tackling those, okay?
So
Dr. Klingborg.
I think that I should wait and have you accept the report before I say anything else. Or
I
not.
move that we accept the report from the Animal Physical Rehab Task Force.
Second.
Any more discussion on that part? Any comments from the public on just that part?
And this is just to get the report before us, and then we'll tackle the recommendations and motions.
Okay, good. Call for the vote?
Dr. Waterhouse?
Yes.
Dr. Sullivan?
Yes.
Dr. Nunez?
Yes.
Dr. Nolan?
Yes.
Jennifer Laredo?
Yes.
Kathy Bowler?
Yes.
Lee Heller?
Yes.
And Judy Mancuso?
Yes.
You're welcome.
Yes.
Would you like a photo now?
It's not quite the Capitol.
Yeah.
Good afternoon, members and members of the audience. As I suggested, one of the things under this tab was the document that I referenced earlier. And I think there may be some confusion, as I said, about what this document stands for. So let me tell you the origin. The origin of this document, it's not a product of the board. It has not been embraced or sanctioned by the board. The executive officer to my left had asked council to come out with essentially a licensing scheme, if the board elected to go there, of what this concept may look like if the board so elected. As you notice, stepping back to the elite, at least the primary four, about definitions and stuff, I felt that it was important that this board have more than just definitions to consider if it would elect to go for the licensing scheme. Because traditionally, for those of you members and others have sat through my board member orientation training, everybody in consumer affairs, every client agency in consumer affairs is a licensing agency. So what licensing agencies do is they determine who gets into a certain profession, what they do while they're in there, and then how do you exit the profession. Some folks who have licenses just go out into that good night, they retire, they find something else to do, they hit all 6 in the lottery, and we never hear from them again, except when a new map comes out and they bought themselves a new island somewhere. Other ones, the licensing agency gently helps them exit the profession. But those are the 3 core functions that a license agency does. And that was sort of the things that I tried to set forth here. Not on the merits. I don't have any skin in the game about the merits of these. These are just things for the board to consider if it so likes how licensing agencies work. Life begins when you file an application. We approve your application for a permit, an addition authority, a license, then you're licensed, and you fall under the agency's regulatory structure. And ultimately, we probably, if you do something awry or in contrivance of that structure, then we would probably discipline you or maybe even issue a citation, okay? So it's nothing more than a sort of a statutory and regulatory framework for the board to consider as it goes forward if it wishes to go in the directions. So let's talk about options available to the board. So it just took in the report. So what can it do? Well, it can do nothing. Thanks, we appreciate the hard work. We don't want to take any action. That's an option. That option obviously may have ramifications in the other policy-making arenas, namely the legislature. The legislature could accept some of these, deny some of these, ask the board to do more research, ask me to do more research, whatever. But it also could say, wow, those were 3, notwithstanding what Dr. Nunez says, those were 3 glorious meetings. A lot of work was done. It may be the simple fact that the board today says we can tackle, like the old Crest commercials, 4 out of 5 of these, 7 out of 8, 2 out of 8. We need to schedule some more time. So we can kibbles and bits it. We just take a few things, we tackle it all, the board does nothing, or whatever. So I don't want to have any misconceptions about what this document stands for, and I also wanted to set forth the options that are available to the board as it considers this item. So on that issue, I know I've talked a lot, which is always a bad sign. Does anybody have any questions? Because I know this is an important issue going forward. Is there any questions for legal counsel about what this document stands for or the options available for the board? Okay, so we're going to get out the cardiac paddles here because I've bored everybody up. Dr. Waterhouse.
Okay, so the first, or did you want to speak some more, Dr. Klingborg?
So if I may, I'm here, of course, as the vice chair of the Animal Rehab Task Force. I'm also chair, as you know, of the MDC, and so one of my jobs is to represent the consumer and the animal, and then I am, as you know, a liaison, and I report back to you. I'm also a veterinarian, and so the things that I say come from those perspectives. But it is my job to give you counsel, and so if I may talk about the eighth motion for a couple of minutes.
Okay, but
Let's tackle, let's hold off on that. I
yeah.
think.
Oh, okay.
So we'll wait, because we're going to take them individually.
Okay.
So let's just look at, okay. So recommendation number 1.
Do you have any comments?
No, I have had all the comments that I needed to make up until the 8th. I think
Okay.
that one's more complicated.
Could you clarify the vote for us, though? I'm interested in knowing what the vote were for each of these 8. Sorry, John.
The vote of the task force was 10 to 8 on motion number 1.
Yeah, so remember, since we seem to have kind of a low spot, my theory with the proceeding was, here's the recommendation of the task force, although it's couched in a motion. The question is, I think number 1 is pending before the board as to what they want to do. Do they want to accept this recommendation of the task force? What does the board wish to do with these?
Question.
Judy.
So, just for clarity, so we're voting on these 4, then we're voting on these 3, and then the final one? Is that what we're doing right now?
I think that's.
One at a time.
One at a time. So we need to make a motion for each one.
If that's what the board so chooses.
Okay, well, I'll make a motion to move the first animal, no?
I think let's discuss things more here.
Okay, so I think the issue would be, like I said, I'm doing this, trying to do this logically. So this was number 1, although there's 2 number 1s. The top number 1, so that was a
June 20th, number 1.
June 20th, number 1. That's a recommendation of the task force. What does the board want to do with that? Does it want to accept it?
Move to accept.
We already did, accepted the report.
No, the report is different.
The report is different. Now we're tackling these ones individually.
Yes.
So move to accept the June 20th, number 1. I
First
move to
definition.
do that.
And I'll second it.
Did you have, Dr. Sullivan?
I guess I'm not clear. Our function is to propose regulations for the protection of the public and the betterment of our patients. So I'm not quite clear on how we're doing this. If we're going to go through each item and either accept it or not, that's fine. But I think this item should be a regulation. So do we address that afterwards then?
We can.
Okay, let's do that then.
Yeah, let's just stick to the program with.
Dr. Nunez?
The way that I understand the process is that there is this field of physical rehabilitation that needs to be clearly defined. And the way that we do things like this is that we eventually start the whole process of writing regulation. It's a very long, long process. But before we start this process, we have to come to a consensus on the basic concepts of what this board believes in. And these recommendations are the basic concepts of what this board believes in. And so what I would propose is that we go down the list and find out if there's an agreement, if there's a consensus on does this board thinks the task force take the recommendations and move forward with them, or does this board feel that the task force has gone a bit astray with the recommendations that were made? So that's, again, we're not writing regulations, we're just kind of agreeing upon the concepts of where this ship, which direction this ship is going. And so
And I would like to approach these one at a time, and I think Anne Marie can talk more about this too.
So there's something that we're doing which is conceptual, and conceptually we're looking at these definitions and these actions, if you will, or motions. Then there's the mechanics. And the mechanics are something that we would need counsel to advise us whether or not this is something that can be accomplished by regulation, whether it's something that can be accomplished by statute. So the mechanics is a separate part of what we do with this once we know what we're trying to accomplish. We need to figure out whether or not this is an acceptable concept for the board to consider, and then we look at the mechanics, and that's where council and myself and perhaps the legislature will weigh in on how we can accomplish this. Do we have the authority to adopt it by regulation? And if we don't, then obviously we're looking at something statutory. And there's not a one-size-fits-all to each of these. There are some here that I can say with some assurance that would be accomplished by regulation. There are others that will obviously require a statutory change because there's no authority in the Practice Act today for us to accomplish this as a board. It's going to require the action of the legislature. So just so we keep those things separate, there's the conceptual language we're looking at, and then the mechanics of how to accomplish that language.
And speaking on behalf of members of the task force, I certainly would hope that this board does consider our recommendations.
Can I, okay. I know we're gonna go one by one, but I would almost, no, forget it. I was gonna say, we could almost like say, let's take the recommendations and pull the ones like on consent and just pull the ones that need to be discussed.
I'm sure some are going to be, have much more discussion than others, so.
Right,
hopefully-
because, I mean, for
yes.
me, I'm good with the recommendation of the task force, and I appreciate the work that they've done, right? So I'm ready to vote on all of them and just boom, let's go. They've done the work, and thank you for it, and have fought the battles and listened to all the voices. So then it would be like, okay, who on the board needs to pull something? And maybe we only need to pull one or two instead of going through each and every one of them. That's just my thought.
Yeah. I tend to agree, but there are only 8, and I actually think one at a time, because it's always the devil in the details. On some of them are, as the chair said, going to
Okay,
be
that's
more,
fine.
We can't assume whatever it
Yes.
is.
more
Okay,
communication.
all right, so let's move. Can we vote on number 1 then?
We have to do discussion.
Oh, I'm sorry. I thought I'm missing something.
I
That
think
there
we
was
have
a
a motion.
second.
We have
Yeah,
a
there was a motion and a
But we have to
second.
discuss.
Just
Discussion,
yes.
we're under discussion.
Oh, we're in discussion mode. Okay, thank you.
I was asked what the vote was on this motion, and I was incorrect. This motion actually was unanimous, I believe. Okay,
See?
so
Let's go.
my sheets here start at the 5th motion, but this
Thank
was-
you for that clarification,
Yeah.
because it didn't match my memory.
Yeah.
18-0 is what you're saying then.
Yes,
18 is-
yes. We may have been missing one, we had one abstention, 17-1. Okay.
Okay, so it is 12:30,
Yes, ma'am.
and so, do you want to vote on the first one, or do you want to break? for
Yes.
lunch?
Well, first of all, we have to go, we have a motion to second.
Okay, that's right, we have a motion.
We have to have public comment on the motion whether to accept the June 20th, 2016 first working definition. Any public comment on that?
Okay, thank you, so, go for a vote?
Dr. Waterhouse.
Yes.
Dr. Sullivan.
Yes.
Dr. Nunez.
Yes.
Dr. Nolan.
Yes.
Jennifer Laredo.
Yes.
Kathy Bowler.
Yes.
Lee Heller.
Yes.
Judy Mancuso.
Aye.
Motion carries. Okay, so we're going to try and move a little further, so go on to recommendation number 2. Can
I
you-
motion that we accept
Can
recommendation.
can you read recommendation number 2?
Recommendation number 2, animal physical rehabilitation does not include relaxation, recreational, or wellness modalities, including but not limited to massage, athletic training, or exercise.
And Dr. Klingborg, the vote on that in the task force?
I'm trying to find it in the minutes here. It was 17-1.
Wow.
The 1 was an abstention. Okay, 17-0-1.
I move to
discussion?
accept.
Second?
Second.
Any discussion? Any comments from the public?
I have a little bit of a question.
Can you come forward, please? And can you come forward, please, and sit at the mic and give us your name?
If you wouldn't mind, that way we can have an accurate record.
Diane Sequoia. It says wellness in here, so I'm presuming what was meant by the task force was maintenance, not treatment of a disease. Is that correct? Thank you for the clarifications.
Any other comments? Okay, call for the vote?
Dr. Waterhouse?
Yes.
Dr. Sullivan?
Yes.
Dr. Nunez?
Yes.
Dr. Nolan?
Yes.
Jennifer Laredo?
Yes.
Kathy Bowler?
Yes.
Lee Heller?
Yes.
Judy Mancuso?
Aye.
Okay, I think you can probably move on and do yet another.
Okay, Dr. Klingborg, can you give us recommendation number 3?
Any proposed changes to existing law and regulations are not an attempt to restrict or amend Section 2038 of the California Code of Regulations regarding the provision of musculoskeletal manipulation modalities. This also was a 17-0 to 1 vote, 1 abstention.
Move.
Second.
Any discussion? Any comments from the public? Okay, call for the vote?
Yep. Dr. Waterhouse?
Yes.
Dr. Sullivan?
Yes.
Dr. Nunez?
No. I mean, yes.
Dr. Nolan?
Yes.
Jennifer Laredo?
Yes.
Kathy Bowler?
Yes.
Lee Heller?
Yes.
Judy Mancuso?
Aye.
Just one comment, this was a little bit outside the scope of the task force. Really, our charge, the task force charge was not to discuss musculoskeletal manipulation. However, it is an action, just for the record, it was a little outside the scope of the task force.
Motion carries. Okay, so, Dr. Klingborg, can you read recommendation number 4?
Prior to performing or authorizing animal physical rehabilitation, a veterinarian shall establish a valid veterinarian-client-patient relationship as defined in sections 2032.1 or 2032.15 of the California Code of Regulations, also a 17-0-1 vote.
Move to adopt.
Second.
I have a question.
Yes.
I just, was there discussion of, and maybe this is later on, about defining prior in terms of the VCPR, like before authorization, is it immediate or certain time period, or was that not considered? This is just the general concept and then we fill in the blanks later? I just didn't know.
Really, you know, the way the VCPR is written and I interpret it, the veterinarian has to have sufficient knowledge of the animal in order to make a recommendation. And so that language is purposefully vague to allow for that flexibility of what does sufficient knowledge mean. But we didn't say 30 days or that was not part of it.
Okay.
Yeah.
Thank you.
Any other questions? Any comments from the public?
The reason for 2032.15, I question whether it's a good idea to include it when we're talking about a veterinarian referring to another third party now. Do we really want a second veterinarian in the mix?
2032.15, that's the in absence of client communication language, and I don't have the Practice Act in front of me. Okay. So, you know, I think the idea here is that the way that 2032.15 really is written and the intent is within a veterinary premise, a veterinarian establishes a VCPR and establishes a treatment plan. And that veterinarian then goes off shift, and another veterinarian in the same premise comes on shift and continues that same treatment plan. And if that treatment plan changes, then that veterinarian, the new veterinarian, must contact the client and reestablish or establish their own VCPR. This was to avoid people where the patient is in an emergency clinic in the middle of the night having to wake up the client at 2 in the morning and say, hey, I'm Dr. Smith, I'm now going to be the doctor. especially if the treatment plan does not change. So that's, the 2032.15 really isn't referral, it's a continuity of care provision.
Okay. I think that's a good explanation.
Thanks.
Any other comments?
James Sims, physical therapist and task force member. Clarification for me, the veterinarian client-patient relationship, and the comment was sufficient knowledge of the animal. Would that include the sufficient knowledge to know whether that animal is appropriate for animal physical rehabilitation?
Oh, that would be my interpretation. Yeah.
Okay.
But by appropriate, I think the question then is, what do you mean by appropriate? Are you saying, is this animal healthy enough? Is this animal, or is this animal in need of that particular thing? I may know an animal needs an exploratory surgery, but it may not be clear that it's appropriate to do that at this time. So appropriate's a tricky word. In my mind, it means there's a recognition of a need of that specific modality, but perhaps not a recognition of whether or not the health status of the patient allows that modality to occur at this time.
So, yeah, I mean, I agree. I think that the sufficient knowledge by the veterinarian of that animal to develop, you said, they establish a treatment plan, and that's to include animal rehabilitation. We have that established here in code. This is a code, not a statute. I just want to make sure that was clear. Thank you.
Just a point of clarification, 2032 and 2032.15 are in fact regulations,
Yeah.
not statutes.
Right, because earlier mentioned statute erroneously.
Okay.
Are we okay? Any other comments? Call for the vote?
Dr. Waterhouse?
Yes.
Dr. Sullivan?
Yes.
Dr. Nunez?
Yes.
Dr. Nolan?
Yes.
Jennifer Laredo?
Yes.
Kathy Bowler?
Yes.
Lee Heller?
Yes.
And Judy Mancuso?
Yes.
Okay. We are now going to break for lunch, and we'll be back in 1 hour. Let's make it, at 1 hour, make it 1:45.
Okay. 1:45?
Yeah.
I know. Beautiful, thank you.
So let's reconvene this meeting of the Veterinary Medical Board. You'd be glad to know that I have cough drops now, and if anybody else wants some, just let me know.
Cough drops.
And so we are, here, making sure that there's cough drops?
Yeah.
So now we're on to the next recommendation, which would be number 4, which was the first one at the October 4th meeting. And so, Dr. Klingborg?
Number 5, I believe,
So,
right?
sorry, 5, yes.
Veterinarians have sufficient education and training to provide animal physical rehabilitation. The motion passed 10-8.
Any discussion? Is there a motion?
Move.
Second.
Okay. Any more discussion or any more questions from the board? If not, then do we have any public comment? Yes.
Before we begin, I just want to make sure the motion was to accept this recommendation, right?
Yes, sir.
Okay.
Thank you.
I know we kind of got in the shorthand there. I just want to make sure.
Would you like the longhand version
No,
going
that's fine.
forward?
I can't even read cursive, so.
Thank you very much.
Hi. I'm a citizen and consumer, big animal lover of all kinds.
And your name
Anyhow,
is?
I'm sorry, Karen Shettle, Sonoma County resident. And just had a quick story about a dog we had that we rescued, had massive injury on the foot that seemed to come from a no supported wrist, an improperly supported wrist from birth. So we took her to UC Davis, and they said, well, we can do surgery at about $5,000. It's kind of 50-50. Or you could get a brace, and we're like, well, you know, who wants to go through surgery? Let's do the brace. Now, a year and a half later, the brace has never worked. It's created new wounds and sores. Nothing has been relieved to help with the pain. And when we went back, we found out, well, you know, this wasn't trained in animal. This was a person who was doing this for us because we don't have anyone that is making these braces. So this is a human brace orthotic person that did this brace. I was like, what? Anyhow, so we have since made, you know, new plans. But what I think everybody's missing here, we got all these well-known people that are in the biz. The public wants the people that do the species that they're trained for to be handling this. We're not having these gentlemen go to see their vet when they need a proctology check. We're not having ourselves go and have our dentist take care of our dog's teeth. We're staying with the species. We don't have people that do anesthesia on primates saying, well, you know, humans are primates. Maybe he can put my sister under and save us some money. No, there's something wrong that people think, because we don't have any problem with these people wanting to do this, but they got to go through the same channels that all of you professionals have gone, and we should not step outside of each species of individual that is on the planet and think that we know what we're doing. And I suggest if we're not careful here, there will be, because the public doesn't know about this really. I just was informed from my rehab person. If we knew about this, we'd be having a fit and looking for class action on anybody trying to push this agenda. And so I just want everybody to back up and think, this doesn't make sense. And even though the world doesn't make sense anymore, we got to get this straight. And I hope that you all do. Thanks.
Thank you. Any other comments from the public? So should we call for a vote?
Dr. Waterhouse?
Yes.
Sorry. Dr. Sullivan?
Yes.
Dr. Nunez?
Yes.
Dr. Noland?
Yes.
Jennifer Laredo?
Yes.
Kathy Bowler?
Yes.
Lee Heller?
Yes.
And Judy Mancuso?
Yes.
Okay, on to number 6. Dr. Klingborg, if you could.
Registered veterinary technicians, RVTs, may provide animal physical rehabilitation under the direct supervision of a veterinarian unless in a range setting, in which case the veterinarian may determine the appropriate level of supervision. And that motion passed 14 to 3 to 1.
Yes, Jennifer.
I wanted to point out that this meeting was in October of last year, and since then there has been a development. NAVTA actually recognized I believe it was a 15th specialty, which is the Academy of Physical Rehabilitation Veterinary Technicians, NAVTA being recognized by the AVMA, who kind of knows what they're doing. So of course the task force would not have had this information back in October, but in light of that, I would move that we amend number 2 to include that RVTs with that specialty could practice either under indirect supervision or under the degree of supervision to be determined by the veterinarian.
Okay, so we have a motion.
Oh, we have a motion.
We had a motion on this? So the motion pending would be to amend this recommendation of the task force to include the 15th emergent class or specialty. Okay. And different levels of supervision.
Kirk, can you get that microphone closer to you, please?
So
I think another a point is, I'll go ahead and speak up here. A point is that the other RVTs in other specialties are not allowed to work under indirect supervision necessarily in all the specialties. You know, for instance, in the technicians who are specialized in dentistry, that still needs to be under direct supervision of a veterinarian when they're performing extractions and such. So I'm very hesitant about that one.
just a note of procedure, do we have a second for that?
No. Chair Waterhouse.
Yes.
I just don't feel like I know enough about what that 15th area is. I would want to feel like I need to read what that training is or what that specialty is before I would feel comfortable voting on that.
I would suggest that we accept this to the board as written, and whatever form we come back to actually write regulations or statute, then we can address that at that time. But right now, I think we should just accept it as written, and I so move.
I'll second that because I think we don't have enough information since it's brand new. We need to consider it and make sure we cover it. But since we have this in front of us and it is brand new, I want to second exactly what Dr. Sullivan is motioned.
Any other discussion?
I need a point of clarification. Dr. Klingborg changed the wording on this to
Oh,
determine.
provide or determine, yeah.
Is the motion going with determine?
The actual word was decide, I found, okay? So it wasn't determine, it was
It
decide.
says provide here. You
That
know
is
that, right?
incorrect. It should have said
Yeah.
decide.
So did everybody get that? We have a sort of correction to number 2. Richard may decide. Okay.
And probably for the purpose of it being more accurate, determine is the appropriate word. So if we're making a grammatical correction, I think we go with determine.
Determine is better, yeah.
Is there an objection that we modify that by the successful motion and seconder? Is there any objection to that? No. Okay. So we'll change our word instead of provide to determine.
Any comments from the public?
Good afternoon, Board. My name is Steven Santal, and I am a NAFTA Board of Director. I am happy to provide any information on the specialties that you would require to further review this. It's also on the aprvt.com website and the navta.com or navta.net /specialties website as well. Thank you.
Nancy Ehrlich with the California RVT Association. We are recommending that RVTs be able to continue to perform animal physical rehabilitation under indirect supervision as they have been able to do since 1974. We're not aware of there being any cases brought against RVTs for incompetent practice of animal rehab, and don't see any reason why you need to be increasing the level of supervision that has been allowed since 1974. And as you're moving forward, and this recommendation, the range setting, allowing the veterinarian to determine the level of supervision. There are 2 levels of supervision allowed under the Practice Act, direct supervision and indirect supervision. There are no other levels, so it's either direct or indirect supervision. And if you require direct supervision, that means even if the veterinarian steps out for lunch, the RVT would not be able to continue performing animal rehab. And as I said before, I don't see any reason why, I don't think anyone can provide a justification for why we need to be increasing the level of supervision that has been in place all these years. In terms of the specialties, RVTs have been able to perform almost all procedures under indirect supervision except for the few that are restricted. So RVTs are able to do dental procedures. They are able to do all kinds of procedures under indirect supervision. If anesthesia is required, then of course direct supervision is required. So I would caution you to look back at the list of the restricted job tasks. Even veterinary assistants are allowed to administer controlled substance when under indirect supervision. So is animal physical rehabilitation more dangerous than injecting animals with controlled substances? I think you need to really consider what you're doing.
Thank you. Any other comments?
Good afternoon. My name is Kristen Hegler, and again, I'm the president of the Academy of Physical Rehabilitation Veterinary Technicians. And thank you very much for bringing up that the Academy has been recognized by NAVTA, and I would support allowing the indirect supervision of the RVTs to continue because that would really restrict what we're already able to do with the veterinarian with the VCPR. This could impact negatively in the future of what happens with our profession, and all of the work that we have done to become recognized as an exceptionally recognized, qualified experts in our field. So I just wanted to say thank you, Jennifer Larido, for bringing that up, and I hope you consider this in the future still.
Any other comments? So we have a motion and a second on the floor. Can I call for the vote?
Can I ask a question?
Yes.
If we say determine the appropriate level of supervision, I mean, that could still be indirect. So we're not making this more onerous.
Just in a range setting, Judy.
I'm sorry?
That just applies to the range setting.
Yeah. The way it's written.
Do you still have a question, Judy?
Well, my question to the veterinarians on the board, is this taking away something that the RVTs have been doing for 24 years or whatever?
Yes.
It is. And why do you see that? I wasn't privy to all those task force meetings, so.
Dr. Sullivan.
Yeah, I would suggest for brevity that we move on, because the only way we can address supervision is through statute or regulations. So we're accepting the report. This doesn't go to regulation. We're just accepting this item. But what it really is going to come down to is what we recommend, this board recommends in regulation and or statute. So I think we're getting tight. I think it's premature to focus on this. Everything is going to come back to supervision when we get to the point of writing regulations or recommending statutes.
Okay, then I'll keep my second, but I'm not looking to take away stuff that they've been doing for decades. Thank you.
And I actually had a question too, because on Judy's same topic. I agree. I don't think that task force was, I mean, I think this, now that I know a little bit more, and on the RVTs, and I think for consumers as well, I would not support this because, as a concept, even a general concept, because it does restrict access and restricts professional right now. If it's available now, and it has been for years and years, for RVTs to do that, then I don't know why we're even addressing it personally.
Well, just a matter of parliamentary procedure. I think right now what we have is a motion to second. We've exhausted public comment. So in order, I think Dr. Sullivan mentioned brevity. I want to suggest that if we want to, unless there's a wish by the prevailing motion and seconder to amend it again, why don't we call the roll on this matter and find out where we are? It does seem a little bit incongruous in some ways that we have essentially a new standard emerging, but then in the final one, in the eighth one, there's some more discretion. So it seems a bit unusual. We're mandating one, but if you look at the last couple lines in degree of supervision to be determined by a veterinarian, so there perhaps may be some internal disharmony here.
Dr. Nunez.
It is true that that is new information that the task force didn't have, that there was going to be a new specialty recognized within the RVT community. And it does seem a bit inconsistent that lower down there's going to be a provision that allows for physical therapists to perform something with additional training, and yet there may be a situation where the RVTs with additional training are not going to be able to perform a task. It seems a little inconsistent.
Dr. Lee Heller.
Thank you. I just want to provide a little explanation rather than taking a position, because there were a lot of people that weren't in the task force meetings. And this is reflected in the tighter votes that Dr. Klingborg has identified. There is a concern in a significant part of the community that, and I don't mean to offend anybody here, that veterinary training and RVT training don't provide equivalent training in animal rehabilitation. So these tied and tight votes were about not feeling that an RVT had sufficient knowledge without additional training to practice with indirect supervision. That's why this came out the way it did. That's why this recommendation was put forward. So it's an explanation of why the task force came up with these recommendations. It doesn't mean the board has to adopt the recommendation.
Jennifer.
And I just wanted to point out what I pointed out this morning, that number 2 that we're discussing currently is contradictory to number 3, where veterinary assistants would need to be under the direct supervision of an RVT, yet an RVT is required to be under the direct supervision of a veterinarian. So that's very contradictory.
Yes, we haven't got to that one yet, so.
Just pointing that out. Just for
Yeah.
you.
Yes.
Well, is there a problem here with number 2? Are we gonna, or can we address it in, once we start writing the regs? We can, okay.
It will present a bit of a, like I said, an incongruous connect the dots when we have sort of the wide open a little bit more down here, but number 5 seems to be creating some sort of a standard, so there is a little a little disharmony.
What's your suggestion, Kurt?
I don't have any suggestions on the merits. Mine is only parliamentary procedure. So, like I said, we have a motion and a second to adopt it with only this recommendation with the word change to determine. And so I would respectfully suggest let's figure out where we are on that. And if that is unsuccessful, perhaps we can figure out whatever 5 should look like as it suits the board.
Dr. Nunez.
I'm going to disagree a little bit with Dr. Sullivan in that I don't think it can be easily dismissed saying that the details can be hashed out in regulation, because the vote that we make is going to count for something. It's not going to be a casual issue. It's going to be on record that this is what the board has accepted. But I do think that it can work out if we do something similar to allowing the veterinarian to determine a level of supervision.
Like the motion I made.
So how about we amend it, or I pull my second and we start over? It sounds like it needs fixing. That's the vibe I'm getting here.
Dr. Nolan.
Yeah, so I'm trying to amend it right now. So
Dr. Nolan had a
I have a
comment.
deeper voice now.
all right. Okay, sorry.
Is this the sort of thing where we have to fix it, or just say, thank you very much, it doesn't quite read right for us, and move on? No disrespect to the task force, but is this the venue in which we are going to hash out wording of this, or I'm just asking for guidance?
Dr. Nolan, at least preliminarily, and again, I'm not on the merits. I know we're near several seafood restaurants, so this matter is the board's oyster, so to speak. So what can happen is, my thought was, when you get down to the last one, you are going to sort of, if the board so elects, sort of ask that whatever these things be framed, I think in recognition of every other thing that you've done here. So, you understand what I'm saying? So this is the framework of all the different you've accepted or rejected or whatever. And then the third and last one would probably be to wrap around, if it's so elected, the statutes are necessary to address what you've gone before. So there would be, and like I keep saying, it is unusual to have the 5th one regarding RVT under the direct supervision, and then we have different under degree of supervision determined veterinarian. So it seems to me logically what we're saying is, okay, for an RVT, unless there's one set, there's a standard for supervision, unless you're in a range setting and there's a different standard. 3 seems to be another hard supervision election, right? It's it's not mandatory, but seems to be a specific level that's prescribed if the board so elects. And then we have some room down here for physical therapists. Now, if that's what the board wants, that's what the board wants. I just want to make sure that we recognize we have sort of a floating level in number 8 and 2 non-floating but anchored, a lot of nautical stuff coming out there, anchored things coming out in 2 and 3.
Dr. Sullivan.
Then I'll amend my own motion
Certainly.
to read, the registered veterinary technicians, RVTs, may provide animal physical rehabilitation under the degree of supervision that is determined by the veterinarian that has established the VCPR.
Would you read it one more time, please?
Registered veterinary technicians may provide animal physical rehabilitation under the degree of supervision that is determined by the veterinarian who has established the VCPR.
Second.
Kathy.
Kurt?
Just
You have a pearl for us, oyster?
No.
I appreciate that amended motion. I'm still concerned, and I want to make sure I understand what we're doing. These are general concepts that the task force has given to us to consider as a board, and we're voting each one, as a board, do we agree in the general concept? I'm still concerned about this one being outside the scope and without being something that, does the board want to agree, which even if you do it under the supervision or at the degree of determination by a vet, it still now changes what's been in practice with RVTs and veterinarians. Obviously, everything an RVT does is at the supervision of a vet, one way or the other. I just don't know why we want to make it more restrictive. Do we need to even consider this to move the ball forward on physical therapy or not? That was my question.
So I think I understand, if I might, Kathy's suggestion is if we did nothing, it would be status quo. Again, there's a difference between mechanics and these conceptual policy considerations, if you will. So right now, we're discussing the policy consideration. So as a public policy, does this board agree that RVTs should be under a different level of supervision than they've always been for animal physical rehab? And if you believe that it needs to change, then you're going to consider a different policy directive. If you said we need to do nothing because the current situation as it stands in the Practice Act is appropriate, then back to Dr. Nolan's comment and to Kathy's comment, you may not need to make a policy statement about this because there is currently a mechanism in place that allows for an RVT to provide animal physical rehabilitation under varying degrees of supervision. It is still determined by the veterinarian, though. So the veterinarian may say, for this animal patient, I need this RVT to be directly supervised.
Right.
For this animal patient, not an issue. So it is still determined by the veterinarian. Us restating that wouldn't change what's in practice today or what's in the application of it. So there's two things going on here. We're talking about globally these kind of public policy statements that we're considering. And then, again, the second layer is the mechanics. If we don't want to make a global public policy statement on this, nothing changes. Does that make it more clear? Okay.
Dr. Sullivan.
But as stated, is that not what we presently do? We're just reinforcing that statement.
Exactly, in the framework of the new policy.
Yes.
Sounds good.
Okay.
The motion that you made.
So we have
Yeah,
a
the
motion.
Yeah, the new one.
Any other comments? Any public comments? Okay, call for the vote.
Dr. Waterhouse?
Yes.
Dr. Sullivan?
As amended.
As amended?
As amended.
Yes. Excuse me. Dr. Nunez?
Yes.
Dr. Nolan?
Yes.
Jennifer Laredo?
No.
Kathy Bowler?
No.
Lee Heller?
Yes.
Judy Mancuso?
Yes.
Okay.
Okay, on to recommendation number 7.
Veterinary assistants may provide animal physical rehabilitation under the direct supervision of a veterinarian or an RVT. This motion passed 10-8.
Dr. Sullivan.
I move we not adopt this.
Second.
So the motion would be that we reject this recommendation, the board reject this recommendation of the Animal Rehab Task Force. Is that correct?
Yes.
Seconded by Ms. Lorena.
Yes.
Okay.
Discussion?
Can we hear a little bit about the whys of the yes, the 10 people that voted for it, what the thoughts were? Mark, Dr. Nunez, can you share?
Why we felt that veterinary assistants should.
Yeah, why
would
is
be
it on the
allowed.
list? Yeah.
Like I said, we felt that veterinary assistants were part of the veterinary team that provided services that included physical therapy. And since we were charged with writing or beginning that process of writing regulations as far as giving the board the authority to oversee that, we had to make it clear that these people could provide physical therapy and also under what level of supervision that they needed to do it. Because you can't regulate what is not in the Practice Act. So we had to address them.
Can you
If-
give,
if-
can you
can
give
I-
an example?
can I add something?
Yeah, and can you give an example of it?
Because we cannot choose a lesser level of supervision for a veterinary assistant than an RVT. And the previous motion passed our committee, our task force, with direct supervision. We could not choose a lesser level of supervision. I mean, that's just the way the Practice Act is written. I think the more interesting question is, why did 8 people vote against direct supervision? I wasn't one of those, so I can't answer that.
Dr. Sullivan, do you want to speak to this?
I didn't hear the question.
Why vote
It was just a follow-on from Ms. Mancuso's.
Oh, my concern on this is it doesn't make sense to me that an RVT has a higher, as John said, could have a higher degree of supervision than what an unregistered a veterinary assistant would have. I mean, this doesn't make sense to me. That's why I'm suggesting it be dropped.
Chair Waterhouse?
Yes.
I think it didn't make sense as recommended prior to the changes we just made in the previous motion. And Ms. Laredo brought this up earlier. It didn't make sense if a RVT had to have direct supervision and then directly supervise a veterinary assistant. You have 3 people in the room functionally, which didn't make sense. The task force's concern about veterinary assistants was simply that they lacked the training to operate with indirect supervision. But if you have direct supervision by either an RVT or a veterinarian, that would address that.
Dr. Nolan?
Yeah, I can appreciate that point of view, but I do feel like the responsibility falls on the veterinarian, and it was a case-by-case decision. So I think the way the Practice Act stands now, that is accounted for in the Practice Act.
Except that there are some tasks under the Practice Act that veterinary assistants have to do only under a direct supervision.
Absolutely.
So the task force was just recommending that this be included as one of them.
I understand.
Any public comment?
I still don't understand.
So here, excuse me, so Anne Marie's going to speak first.
I don't read the Practice Act right now that would prohibit a veterinarian from assigning to a veterinary assistant this under indirect supervision. The Practice Act does not say this would have to be under direct supervision. It actually in 2036.5B, I'm just pointing this out, I think there's a misconception here that if we didn't adopt something that it would be under direct supervision, and I don't see anything here that limits a veterinary assistant from doing this under indirect supervision.
I was going to make the same comment.
Okay.
And I wasn't saying that. I was saying there are some tasks that do require direct supervision, not that this was one of them.
Valerie Fenstermaker. I just have a question as to how you see this playing out in the Practice Act, because when the chiropractic language was written, it's all very clearly laid out under musculoskeletal manipulation. If this is all clearly laid out under animal rehabilitation and some things aren't in there, will that be confusing to all of us who are trying to interpret the Practice Act? So is more whether it's direct or indirect, or as veterinary assistants, RVTs, whatever, is better under, if it's a separate section, rather than less, where you're trying, this isn't just another task, where we seem to be breaking it out as something different. So I just want to put that out to you to consider, because in the end, we have to try and figure out what it means, and I think more might be better here.
Stephen Satal again, hello. So I think the other problem is we go into semantics. So anybody that is not credentialed coming into the veterinary practice can be considered a veterinary assistant until California has a certified veterinary assistant program established. So we can have very qualified human physical therapists come in, hired as a veterinary assistant and performing these tasks without direct supervision. I just didn't hear that clarification in there.
That's a very good point. Yeah. Yes, thank you. Any other public comment?
And the motion is just, the motion would be to reject this recommendation of the task force. That's the motion that's pending.
And has been seconded. Yes, so. Yeah.
So have we exhausted public comment?
Call for the vote?
Okay. Dr. Waterhouse?
Yes.
Dr. Sullivan?
Yes.
Dr. Nunez?
Can you come back to me, please?
Okay, sure. Dr. Nolan?
Yes.
Jennifer Laredo?
Yes.
Kathy Bowler?
Yes.
Lee Heller?
Yes.
Judy Mancuso?
Go back to Mark here.
The answer is no.
Okay, no?
Yeah,
And-
my inclination is no. I'm going no.
Okay. 2 noes.
So are we able to
You can
amend?
offer up a different motion, yes.
Let me think of one.
Okay.
Okay, I move that we add that veterinary assistants provide APR under direct supervision of a veterinarian, period.
Okay.
Wait, can you read the whole thing, please, then? Exactly like
That
it
is
would
the
be.
whole thing.
Oh,
Do you want me to
What do you
read it
mean?
for you, Jennifer?
So we rejected that one.
Yeah.
No.
Right, but
So-
before we tackle that, does the board, so is it, I understand it, that's we are now entertaining new motions
Yeah,
about the standard, is that,
It's just a substitution.
okay, all right. So Ms. Laredo, go ahead, I'm sorry, I didn't quite hear what you said there.
Veterinary assistants may provide animal physical rehabilitation under the direct supervision of a veterinarian.
Second.
Okay.
Any discussion on that?
Chair Waterhouse? So the gentleman in the audience, I think, raised a compelling issue, which is why I actually voted the way I did on the last motion. If you had a qualified a physical therapist working in a veterinary practice, but as an unregistered, to use our old language, veterinary assistant, because they're not an RVT, they would be required to practice under direct supervision. And that is exactly the kind of thing that we're pushing back against in terms of too much burdensome access to the public, and probably a waste of the veterinarian's time. So it really determines who the veterinary assistant is, whether or not, so if it's a mandate that it always has to be direct supervision as opposed to at the discretion of the veterinarian, as in the previous item, we have that problem. If you have the degree of supervision to be determined by the veterinarian, you have the flexibility that you're not preventing this veterinary assistant, who happens to be a highly trained physical therapist, from operating on the premises, but with indirect supervision.
Judy?
but it's a may, not a shall.
I don't think she's offering it as a, well,
She read
I
it
think
as
may
may.
functions as a shall. I think may
Yeah.
functions as a shall.
It's a shall provide?
How was the motion exactly? Can you read-
So
read the
it's
motion?
the discretion isn't about the supervision. The discretion is that a veterinary assistant may provide, not the supervision may be direct supervision. So the discretion isn't, the emphasis isn't on the supervision in this sentence. It's on that the veterinary assistant may provide it. They may not.
Ah, got it.
So it's, yeah, it's placed in a different emphasis there.
Exactly, yeah.
Veterinary assistants may provide animal physical rehabilitation under the direct supervision of a veterinarian.
Kathy?
So if they do it, it's under direct supervision.
Right. And to Lee's point, the one thing I think that's a little different from his example to what the task force considered all along is this is opening it up to non-certified animal rehabilitation, physical therapy. You know, if you have a physical therapist that's human certified and comes in to do work on it, on your pet at a vet office, I frankly, as a consumer, would prefer they have extensive additional education, et cetera, et cetera. And so I think this just says if you're an unlicensed person in a vet practice, that you have to be under the direct supervision. Because RVTs are licensed and accredited, and then same. But a physical therapist necessarily, without going through the extensive additional training we're talking about in number 8, does not carry that same weight in my mind. So that's why I like the Jennifer version right now.
Any public comment?
Marshall Scott, veterinarian. I object to this in some regard because all physical therapy is not complicated. A case would be that an animal may come in and all we need is somebody to hose it down. And I don't think that would need my direct
I don't think that's
supervision.
physical therapy.
That's not physical therapy as defined in this document.
Well, to me, that would be part of it anyway. But anyway, there are different levels of physical therapy, and I think it should be still under the discretion of the veterinarian.
Thank you.
Well, but he's,
Those are some of the clients.
hydrotherapy, yeah.
Hello again. I really like your motion, Jennifer. I would like to add, with the advent of the new specialty and some of the other advanced certification courses, that we amend it to include an RVT with advanced training in physical rehabilitation for direct supervision of a veterinary assistant.
I'm fine with that, but I don't know if my second would agree to that.
To be honest, this is the first that I've heard of this. I'm a little uncomfortable. And as we go through the regulatory process, if we can do it through regulations, we're going to have plenty of time to sort that out. So right now, I'm a little uncomfortable.
And I stand by my motion.
And perhaps what we could do, members, if when we get down to the future agenda items for the next meeting, perhaps there would be a spot to tackle that as well.
Dr. Nolan?
Well, I think that I do have a question about this. Henry, did you say that right now veterinary assistants can, at the discretion of the veterinarian, with indirect supervision, do this? Because the example used is very common in large animal practice. We have hydrotherapy very often that has to be delivered by someone that's basically standing there with cold therapy with a hose. So if you're going to count that, but it's a treatment of an injury illness with a physical corrective treatment, it falls into the category in my mind. So I think it makes it a lot more wishy-washy to me as to whether it should be direct supervision from the large animal world.
Dr. Nunez?
My opinion is that you already did not accept the recommendation, so that things would stay as they are. I personally don't see a need to make another recommendation, since you've already said to leave it as it is. I don't think it's going to be very substantive, so I'm going to be voting no.
It is a change if we go with the motion.
Any other public comment?
Why don't we state the motion just for...
Okay, sorry. More public comment.
Just the last one. I just wanted to clarify or just bring up that if a veterinarian determines that I can go treat an animal patient under their indirectly, and I need an extra set of hands, that vet assistant, they need to come with me under the direction of the veterinarian. So if a veterinary technician is supervising the vet assistant, then that should solve our problems, I think, that we're talking about here. That's all I wanted to say.
That makes sense. Doesn't it?
So can we restate the motion?
Veterinary assistants may provide animal physical rehabilitation under the direct supervision of a veterinarian. Get a motion by Jennifer Laredo and a second by Dr. Sullivan.
To call for the vote?
Dr. Waterhouse.
Yes.
Dr. Sullivan.
Yes.
Dr. Nunez.
No.
Dr. Nolan.
No.
Jennifer Laredo.
Yes.
Kathy Bowler.
Yes.
Lee Heller.
No.
Judy Mancuso.
No.
Okay. I think we've got a 4-4. So the motion doesn't pass.
So can I clarify, as we stand now, we have RVTs with direct supervision under, to be determined by the veterinarian, but veterinary assistants without any level of supervision?
There's
No, they have to be direct.
You just got to speak because your voice is soft.
So as we stand now, we have RVTs with their degree of supervision to be determined by the veterinarian, but veterinary assistants with no level of supervision at this point.
No. Well, that's not good.
Wanted to clarify that.
All right, that's
Well-
not good.
It's not true.
That's not true.
It's still under the discretion of the veterinarian.
The current practice act.
So
Current
as
practice
is,
act.
the current regulation is veterinarian determines level of supervision. So it's not no supervision, it's veterinarian determined. If we do nothing, if we don't accept the task force recommendation, then we have the status quo.
And couldn't it be that the veterinarian then says to this woman's scenario that it's okay for Jennifer as the RVT to have a veterinary assistant with her doing whatever they need to do? That happens every day in your practices, correct? So that's good.
It would be permissible, yes.
Yeah, so that's fine.
That's current, right?
Well, I'm trying to keep score at home. And,
Yeah.
The way I have it is, number 7, or the third recommendation of the October 4th, 26th meeting has been rejected, and its substitute motion has been rejected as well. So far, we have approved 6 out of the 7, just for those of you that are, like I said, 2 out the bottom.
And we're
of the
just saying that
Yes.
number 7 isn't needed because it's under current law. We're just going with current law. And to Valerie's point, if we need to just call that out in this new section, we call it out. You know, the more versus less thing.
So I'm confused if we're comfortable as a board, you, with the status quo, why you don't build off of the previous motion that you passed about RVTs providing animal physical rehab under the degree of supervision as determined by the veterinarian who established the VCPR, and substitute the word veterinary assistance there, which I believe is the status quo. And just keep that clear as you do your writing in the future.
Someone can make a motion.
So is there a motion before the board?
Sure, I'll make a motion. That veterinary assistants may provide animal physical rehabilitation under the degree of supervision to be determined by the veterinarian,
Who
who has established the VCPR.
Second?
Second.
Discussion. Any public comment?
I don't think you realize what you're planning to vote on. You're planning to vote on allowing a person who walked in off the street to have the same levels of supervision as a RVT or potentially a physical therapist with an animal certificate. The previous motion that came out of the task force was the logical one, which was that the veterinary assistant be under the direct supervision of either the veterinarian or the RVT, which would allow them to be under indirect supervision of the veterinarian in the scenario that Kristen raised, where if an RVT is being sent to an indirect situation, they bring a veterinary assistant along with them to help. That person is then under the direct supervision of the RVT. Right. But in the scenario that you're creating, this person is under the supervision of the veterinarian who's not present. Right. And this person may have no particular training or qualifications. Now, of course, you're relying on the veterinarian knowing that this person has the skills and knowledge, but yet you're going to be requiring certification for a physical therapist, and you require an RVT to have a license. I don't think this is particularly logical.
But
Yes.
again, this is what is in existence now, correct?
I'm Jessica Waldman. I'm a veterinarian certified in rehab and acupuncture. I've been on both rehab task force, the first one 10 years ago. Just regarding this topic, I agree with Nancy, and I can give you some scenarios since I followed the small animal rehab world pretty closely over the past 10 years. There was a practice about an hour away from mine where a dog groomer.
Hang on just a second. If we could just have comment about this motion itself. I don't feel it's appropriate we drag in anecdotal evidence that hasn't been discussed about the merits. So if you want to relay your position that you in fact think there's a loss of consumer protection, or this is illogical, or this flies in the face of convention of commercial treatment plans, something like, that's fine. I'm a little bit concerned about bringing in anecdotal evidence from other parties.
Okay, so along those lines, would definitely be a loss of consumer protection, because examples I can think of that I think we can all consider would be a groomer doing a rehabilitation program off-site at a clinic owned by a veterinarian with nobody there, with no credentials, and I think that that's a possible and likely scenario that could happen, and that seems really unfair to the consumer that's unable to see if that person is qualified or not.
Hi, Diane Sequoia. I hate to nitpick, but you did mention the veterinarian who established the valid veterinary patient-client relationship. How long ago was that established? I would prefer to see current or valid, meaning it's within the past year.
Any other public comment? Yeah, let's repeat, yeah, we're getting.
Okay. The motion on the table, veterinary assistants may provide animal physical rehabilitation under the degree of supervision of a veterinarian who has established a veterinary client-patient relationship.
That's been motioned and seconded.
Determined by the veterinarian.
Okay, so we have a motion, and Judy, you have a question?
And this is reiterating current law. Yes, it is. And what this means is if a veterinarian feels that a veterinary assistant, unregistered person off the street is okay to do something with, at all, period, or with an RVT overseeing it, that's fine. That's what it is today, and that's what it'll be after we vote on this. Is that correct? Thank you.
Kathy?
And I agree, yeah, I assume it is what's current in the Practice Act, but again, I don't know why we have to reiterate it, because it still sounds from the outside world as a consumer that an unlicensed veterinary assistant has more abilities than an RVT, because an RVT has to be determined by the vet as well, yet they're certified, they're presumably they're educated and blah, blah, blah. I agree that I trust my vets implicitly with their determination of who on their veterinary assistants are qualified to do what, but I don't know, if it's current, that's what happens. I just think it does a disservice to credentialed RVTs to sort of put this in here at all, but, because it doesn't change anything if it.
And that goes back to what I was saying before, that we could just call out to current law and we don't have to create anything. I think to Valerie's point, that if we are creating a new section in the Practice Act, animal rehabilitation, and we need everything in it, it's fine that we put that sectional law that exists in there that we're referring to, and we don't have to recreate it. What I heard from Anne Marie is that the only reason why we're voting on these, and that Dick said as well, is the framework in which we're building those regulations. So what we're saying here is we are going to use current law in order to build those regulations on the level of supervision of a veterinary assistant or an RVT. I mean, that's it. Really? We don't even need to be voting on it or have it here then if that's what's going on. But if it's just a part of the framework and that's what we're voting on, I'm fine with it. I'll second it and let's move on. If it's something different, then we all need to know.
Jennifer.
And I just wanted to clarify, for the last motion, we changed the degree of supervision that RVTs have been under for the past however many years, but we're leaving status quo for veterinary assistants.
No, I did not hear that on the last one. I did not. Or maybe I didn't, I voted against it. Oh, that was the one I voted no to? Yeah,
Yeah, see,
The difference being in current practice acts, since everyone's confused, is that RVTs, as many of you know, have very specific tasks that have to be under direct supervision. Everything else is understood that can be done under indirect supervision. So from the standpoint that this now says we may be able to require RVTs do it under direct supervision if that's what the veterinarian discerns is appropriate, whether or not you consider that a substantial change from the current practice act or not depends on how you view the discretion of the veterinarian who is delegating tasks to the RVT. I think it is always incumbent upon the veterinarian who's delegating any tasks to say, this animal patient has a significant health issue or is medically fragile, I need to directly supervise anyone treating this animal patient, whether it be an RVT, a veterinary assistant, or a physical therapist. The veterinarian has discretion to do so. Because remember, that animal patient is the patient of the veterinarian, not the RVT, not the veterinary assistant, not the physical therapist, and not an unlicensed person. So this just really restates the hierarchy that exists in the Practice Act. Now, it does change the wording, if you will, that it calls it out as a specific task that the veterinarian will decide the level of supervision for an RVT, which currently it says RVTs can do these 5 things under direct supervision and everything else can be done indirect, and that is permissible. But it doesn't remove discretion from a veterinarian saying, in any case, that I have a medically fragile patient and I have to directly supervise any care and treatment for that patient. Kurt, do you have any?
No, my only concern is, again, on the merits, and when we get down to the last one, about irrespective of what's current practice, whatever, I think, in all candor, these are some pretty significant changes in the act. It would be my advice, as the board considers number 8, that I do believe you're going to need a statutory revision to sort of clear the path and provide the cover for any implementing regulations. So, to the extent Ms. Fenstermaker said, what to put in and what to put out, the way this is going is animal physical rehabilitation is a set-off task. It's a set-off thing, it's not something that's in the Practice Act now. We have some disclosures of what we're not intending to do. We're changing some of the supervision requirements. So when we get down to number 8, I'm gonna be recommending as your counsel that if and when you go forward, you do so under the guise that some statutory revisions will be necessary. So to the extent that colors everybody's judgment about what to put in and what to put out, I just want you to know that. I would respectfully suggest that we have a motion and a second pending. We've exhausted a lot of public comment. We've heard a lot of internal debate. So moving forward, why doesn't the board consider, dispensing with that, seeing where we are, and then perhaps we can get on to the last one.
Could we restate the motion again?
Veterinary assistants may provide animal physical rehabilitation under the degree of supervision as determined by the veterinarian who has established a VCPR.
One last comment. To me, on the enforcement side, the person that has the responsibility in all of these scenarios is the veterinarian with the VCPR. And Section 2035, Duties of Supervising Veterinarian, specifically says, the supervising veterinarian shall be responsible for determining the competency of the RVT, permit holder, or veterinary assistant to perform allowable animal care tasks. That, to me, puts it in perspective that as enforcement, I'm going after one person, and that's the person who has the VCPR and delegates the responsibility. If something goes wrong, I'm going after that licensee that we have full control over. So I guess I'm a little concerned about us getting hung up on the RVT's duties and the veterinary assistant. I think it's somewhat of a smokescreen because the person that's responsible is the veterinarian. There's no way around it.
That's right.
Any other comment? Yes, Nancy.
Under the scenario that Dr. Sullivan just raised, then we don't even need to discuss item number 8 because physical therapists are veterinary assistants under the Practice Act. And therefore, you just leave it up to the discretion of the veterinarian to let a physical therapist perform, any physical therapist, or any person who walks in off the street can perform physical therapy on animals under direct or indirect supervision, and the board has no say-so, other than going after the license of the veterinarian if they determine the person was not as competent as the veterinarian thought. The whole purpose of this task force was to write rules beyond that, leaving everything up to the discretion of we wouldn't need the task force because under that scenario, none of these regulations are necessary.
We have
the Practice Act already allows physical therapists to perform animal rehabilitation under animals under direct or indirect supervision and the discretion of a veterinarian.
That is what we're defining, and I think the task force did a great job in bringing that forward, but we're the ones that are going to have to decide at what level the supervision is.
Well, you're going to require, at least I suspect you're going to require that a physical therapist hold a certificate in animal rehab before they can perform physical therapy at all. And yet you're going to allow a veterinary assistant to do it with no qualifications.
That has not been decided in any degree.
We haven't gotten there yet.
You haven't gotten there yet, but I'm just suggesting that was the direction that you appeared to be going in. But all of this has been a waste of time if this is the end result.
Dr. Nolan.
In my mind, one of the issues is the probably lack of detail on the definition, because there is such a plethora of things that are considered treatment of injury or illness with physical corrective measures. It's very broad, and I think I agree with Valerie. If we don't define that more clearly, then we probably should, I don't think we should be calling that out as a separate entity in the Practice Act.
If I can be so bold, I think we need to focus on the motion. So the motion, I think, if the board wishes to return to one of the above about whatever the definition of APR is, we can certainly do that. But I think having, like I said, exhausted public comment on this issue and having the matter ripe for resolution would be my advice as your counsel. We'll take the vote. We'll see where, if there's other things that the board wishes to consider, we can do it after we dispose of this one issue that's before us.
Okay, call for the vote.
Dr. Waterhouse?
No.
Dr. Sullivan?
Yes.
Dr. Nunez?
No.
Dr. Nolan?
No.
Jennifer Laredo?
No.
Kathy Bowler?
No.
Lee Heller?
Yes.
Judy Mancuso?
Yes.
Okay. The motion does not carry. 5-3.
May I make a suggestion? We just skip this and go on to the next one? It seems irrelevant at this point.
You make a
Unless someone makes a motion, that's what.
No?
Okay.
No?
No?
Okay, move on.
Yeah.
So I think that is a great suggestion. So, moving on.
Oh, I thought we had the hash.
Two.
Again.
But the attorney here says, no, we don't have to.
We
have a
don't
motion.
have to. Okay, thank you.
You've, the board has dispensed with everything except for the final one. Of course, there is room, the board may want to entertain some other conceptual ideas that it wants to follow as well.
Yes, I agree. Let's take a break, and then we will come back to item number 8.
So my door.